Welcome, everybody. I'm Ed Rock, along with Rob Jackson. I co-direct NYU's Institute for Corporate Governance and Finance, and we're thrilled to have everybody today for our spring roundtable, which I'm really happy to be organizing along with April Klein from the Stern School, where she runs the Ross Center for Accounting. This roundtable has two origins. The first is that clearly a political decision has been taken for the SEC to move forward with mandating ESG disclosure. And that raises an incredibly interesting set of questions that we're going to address today, which is, given that that decision has been made, what should the SEC do? And we've put together a wonderful group of people from, I think, all corners of the ecosystem, the corporate governance and capital markets ecosystem, to address this question. The second origin for this is really much more personal. It's to help out Satyam Khanna, our former research fellow and friend, who is now at the SEC, and John Coates, our longtime friend from corporate law circles, who's now head of corporate finance. They're tasked with this incredibly difficult job of figuring out what the SEC should do. And really the purpose of today is to help John and Satyam figure out what to do. And the theory that the best securities regulation is sensitive to what market participants are doing and what market participants think is the appropriate way to move forward. We are going to record the proceedings today and post them both to our website and to April Klein's Ross Center website, so that folks at the SEC, folks outside the SEC, people interested in this set of issues will be able to hear what we talked about today. If people in the audience have questions, put them into the chat box or the Q&A box, and the moderators will do what they can to weave them in to the discussion. So with that, let me turn things over to April.
April, I think you're on mute.
Thank you. The most common words of Zoom, you are on mute, right? Okay, again, thank you, Ed. I'd just like to say it is a pleasure for the Ross to partner with the Institute for Corporate Governance. This is our third partnership now, and I think we're like wine. I just think we keep getting better as time goes by. I think this question of looking at ESG disclosure and particularly what the SEC should do is just the ideal place for the law school and the business school to get together and to put our heads together and to ask questions and perhaps even to offer advice. I really have nothing else to say. I think Ed set the table very well. So let me just turn it over to Rob, and we can actually give John an extra 5 minutes, John Coates an extra 5 minutes to talk to us. Thank you.
Well, thank you, April, and good morning, all. Thanks so much for joining us here at the Institute at the law school, and in partnership with our friend and colleague April Klein at the business school. We are thrilled to be hosting this morning's event. As Ed and April have explained, the genesis for this conversation is to share what we think here at NYU is our one of our many expertise, which is to bring together market participants and their expert experience working with corporate boards of directors and investors across the marketplace to help regulators understand what a sound regulatory infrastructure looks like on contested questions. And whatever one thinks about the future of ESG, it is certainly that. And we are thrilled to have the chance to share with regulators, many of whom are joining us this morning, listening in to the insights from our friends in the market about what is a workable, sustainable, so to speak, path forward on providing investors with information about the issues that are increasingly top of their mind. including, of course, issues around climate. To kick off today's proceedings, and as you've seen the agenda, you know we'll be hearing from market experts of all kinds, folks in the boardroom trying to counsel in-house, and of course, corporate lawyers and investors alike. But we're going to begin with our friend, NYU graduate and my longtime colleague, John Coates. John has an impeccable background and record that began here at NYU, and there is really, so far as I can tell, only one mistake in his career path, which is that he was my corporate law professor once and is therefore responsible for all of my mistakes. John was named acting director of the Division of Corporation Finance back in, John, am I right that announcement came just around January, February, and for the last 2 or 3 months has been leading the division, taking the helm of the division that as many of you know, will provide guidance to the marketplace about the path forward on issues such as climate and ESG more generally. John, good morning, and thank you again for joining us here at NYU.
Happy to be here, Rob, and thank you very much for that kind introduction. And I'm glad you mentioned that I'm a NYU alum, because I am. I'm proud of it.
Well, John, I want to get right to the questions because I know many in the marketplace are interested to hear your views about the matters that will be our focus today, and of course, in particular, ESG and climate. But first, let's start with my friend Gary Gensler, who was just sworn in not too long ago. As I see that he's completing his second week at the helm of the commission. How's it going? Have you had a chance to sit down with him to discuss his priorities and to get a sense for the path forward for the Division of Corporation Finance and the Securities and Exchange Commission?
Happy to unpack that in a second. Let me start with the usual disclaimer that anything I say today is, my views, not necessarily those of the commission, the commissioners, or others on the staff. Having said that, yes, Gary and I have chatted. It's great to have him on board. I think his energy and experience are evident every time anybody ever talks to him. I think it's fair to say that he's still reviewing the overall potential agenda for the agency, and we do have limited resources. So he's still thinking through how exactly he wants to spend our marginal resources. He has made it clear, though, both publicly and internally, that he's going to continue the efforts that Commissioner Lee initiated when she was serving as acting chair on ESG disclosure. And so, that encompasses climate, human capital, diversity, potential other topics. But for the congressional writer, it would include corporate political spending, I believe, although that is currently something we can't finalize rules on for the moment. If I had to guess, and this is more of a guess than anything specific that he's said, crypto, he used to teach about that at MIT. He has an interest in it. I do think it's likely that will be a piece of the overall agenda, both for the agency and for the division. We'll get to look hard again at the Howey test, for those of you who remember your securities law. And I think that's kind of about all I can say. I would say keep your eye out for the spring Reg Flex agenda, which we'll be putting out relatively soon, and that'll give you a broader sense of additional rulemaking initiatives that we might take on.
Well, I think that's a very helpful starting point, folks. And for those in the audience who might not be aware, as John's pointed out, this very shortly, the SEC will put out a regulatory Reg Flex agenda. Historically, that's provided very useful guidance as to the path forward from a rulemaking point of view. So I'm sure the market will be watching closely, John. You mentioned former acting chair, now Commissioner Allison Lee, my friend and former colleague on the commission. And among the many impressive initiatives that she moved forward during her really exceptional leadership was she opened a comment file providing a lengthy request for comment, asking a host of questions about ESG disclosures, and particularly focused on climate change. I've been watching that comment file. I get the impression that the market is following it too. Just the other day, actually, an issuer came forward. I believe it was Uber, John. Who's a terrific GC, Keir Gums, has been a leader on this subject as well, have come forward in favor of mandatory disclosure on certain climate matters. What are you seeing in the comments? And how do you think the comments are going to play into the next steps on climate disclosure and mandatory disclosure on climate?
Like you, we're tracking it pretty closely, and I also saw the Uber letter. That we've had a few others that I've had, a pretty good substantive material included in them, and they'll have an impact. I mean, the bottom line, it's as we'll talk about. There are a variety of choices that will need to be made, both at the agency and elsewhere, as ESG disclosures get stood up in a more serious way than has been the case in the past. And the letters are going to inform us about both ideas and sentiments and challenges that different choices might lead to. So we're going to be looking, across the spectrum. We're also, just add to this, we're engaging, kind of directly with a variety of stakeholders. And so both through the comments and through the engagements with companies, with trade groups, with investor groups, with investors themselves, standard setters, government counterparts in the U.S. and abroad, we're going to be taking all that information in. I'll add one little, suggestion to people, which is we have a June 13th ending to that comment period. Sometimes those ending periods are treated as if they're kind of soft and, you can keep sending stuff in. Of course, that's still true here, but I will tell you, we're not going to be moving slowly. We're going to be moving relatively promptly on this front. And if you really want your contributions read, I'd send them in earlier than June 13th, because June 13th probably will be something like, 3,000 comment letters hitting that day. I may be overshooting it a bit, but there'll be a lot. If you get them in earlier, like the Uber one, we will be able to spend more time carefully reading them right away. We will eventually process all of them, just to be clear, but it may take more time for the ideas in them to get into our head. So sooner rather than later would be great.
So John, are you suggesting this deadline maybe not quite as soft as the deadlines you faced as a law professor? We have some hard deadlines, grading deadlines. We take very seriously. I think they actually take money away from us traditionally if we don't get our grades in on time. But yeah, other deadlines, there may be some softness in academia. And in fairness, sometimes the comment file deadlines are kind of just nominal. This one, again, if it comes in on the 14th, it's not like we're going to ignore it, but we're going to be moving as quickly as is reasonable and is responsible in this area, because frankly, in my view, it's overdue. And nobody else is waiting. The rest of the world is moving forward pretty rapidly. Makes sense. And I think many of the authors of potential comments are on the line today. I hope they'll take your advice, because it makes sense to me that having them all come in on the last day is unlikely to be as constructive as it could be. Within the breadth of the comment file, John, are there particular questions or topics which you're grappling with, or on which you suggest the market participants in today's audience engage?
Yeah, I'm going to flag one that I'm particularly thinking hard about. We can maybe talk a little bit later about why, but let me just get the issue clearly framed for everybody, in case this is the only thing you hear today. And that's question number 6, which is about a standard setter. What should one exist? Should there be requirements for it? Think about its governance. And the reason, the quick reason for this is that it seems clear to me that over time, this is not a 1 or 2 year effort. This is going to, disclosures in this space are going to have to evolve over time. And I can give some examples later if you're interested. That means there has to be, ongoing work streams. We could try to do that at the commission, but there are many reasons why that might not be the best model. It's not the model we've used in financial accounting. It suggests that there might be a value in there being a designation of a climate or ESG. And so one question is scope, but a standard setter to take up the ongoing task of keeping the disclosure standards in this area fresh and taking on new challenges as they emerge. There are a lot of very specific kind of governance questions that law professors and business professors might usefully contribute to. How should the board of such a standard setter be constituted? What kinds of limits or requirements might there be for how it's governed? What kind of process should it follow to make sure that it's getting full information before it presents new standards? How should it be funded? Those are all questions that I think would be very helpful to hear from the public about.
John, let's come back to, in particular, the governance design of such a standard setter, because I know that that's something that lots of folks are thinking through. But in the meantime, let's first begin with rulemaking. Because, John, I must tell you, my strong sense is that the marketplace is anticipating, understanding, maybe even expecting mandatory disclosure rules to come from the division in this area. Let's assume for present purposes that the market's expectation is right. Let's assume that you're going to move forward on some kind of rulemaking and as promptly as you've suggested this morning. What are the main challenges you think about when crafting such a rule? Having been at the commission recently, I'm aware of some, and I'm wondering which are top of mind for you, John.
Well, there are some general challenges that affect any rulemaking. Again, I alluded to resources, and there's a limit, frankly, to how many that we can practically develop, propose, consider, and adopt in any given time period, because there's let me just comment. As an academic, I was insufficiently appreciative of the number of people who very helpfully contribute to any rulemaking. I've already seen some of, in the time I've been there. There was the holding foreign companies accountable interim final rule we just adopted in response to the statutory mandate there. And so I've seen kind of the way it works. And I understand why as many people contribute as they do, but it does mean that it's time consuming, resource consuming. And so that's one obvious overall thing. I think, high priority items like ESG, we will find the resources to do it. So that's maybe not directly as much a challenge here, but it might be for other topics people are interested in. It will be an ongoing challenge, again, to revert to the need to keep it updated over time, keep the disclosures updated. More specific to ESG, I think there's going to be this trade-off. There's some disclosures that I think are going to be plausibly material in a general enough sense that they're going to cut across all industries. And then there are going to be others that are really actually much more specific to industries. And so we're going to have some trade-offs to make about where to draw lines there. And how to think about the industry level disclosures, and again, whether to do those ourselves or whether to have those handled by a standard setter. There's going to be the challenge of trying to write requirements in a way that will elicit useful information in a consistent and comparable way, which, to the extent we can, build in mechanisms for assuring reliability. And that phrase all those things I just said, those are hard challenges. It's simple enough just to say we should have climate related disclosures. It's much harder to get down to what exactly do you mean, and how are you going to make sure that the way companies respond is in fact consistent, and how, if at all, can we be sure that the information provided is useful and reliable. So that's a basic challenge. Yeah. And let me just add one quick other one, because I think it's important to keep in mind. And that's just the basic cost-benefit trade-offs, right? How much detail and how comprehensive, how much liability, public or private, controls, do we mandate assurance or do we leave that to private choice? Cost of capital is affected. Cost of capital raising is affected. Cost of compliance, all of those things, and they're often difficult choices at the ground level on how we're going to set rules. I'll stop.
I think those are all important points, and I just want to dig in on them specifically. First, let me start by asking you a question that's on anyone's mind, especially now that you're in the position of making the rules, I'd be remiss not to point people to your famous Yale Law Journal article about cost-benefit analysis and the organizational design challenges that a regulator faces when they're subject to the prospect of facing litigation over the cost-benefit analysis that has to be done when you mandate disclosure. Now that you're in the seat, John, rather than writing the article, tell me how you're thinking through that.
Well, so far I haven't had any dramatic, moments on the road to Damascus. I do continue to think that the most important costs and benefits, which I just sketched, cost of capital, very hard to actually estimate with any precision in advance of a particular rulemaking. Cost of capital raising, likewise. Compliance costs, easier to estimate, but often very difficult to anticipate the sustainable trajectory of them over time. And so I continue to think, as I made clear at great length in that article, that doing quantification in this area is genuinely difficult, that we should try, but I don't think I've changed my mind that ultimately the questions involved here are going to be judgmental, and that should lead to a degree of modesty in how strong we make claims about cost and benefits, and it also should lead to courts being more deferential than they sometimes have been in reviewing our rules.
That makes sense, John. You mentioned one particular type of cost that I know is on the market's mind. And I would be remiss not to ask you to say a little more about the prospect of securities law liability for any disclosures that are mandated. My sense is that, I'll just give you the standard concern that's reflected in the accounting literature. And I know our colleague and friend April Klein is going to lead a panel to discuss that right after we finish. But the concern, John, is that if there's the risk of liability, what you'll get is boilerplate. Because conservative lawyers will advise clients conservatively with respect to securities law liability. On the other hand, if you provide some sort of safe harbor or some other kind of treatment, you might get a different kind of result. Tell us how you're thinking through that balance, John.
Yeah, so let me say a couple things about liability. First of all, let's get our baseline straight. When a company today, in response to investor demand, which often feels, they tell me, as if it's not a choice, they have to respond to certain kinds of investor demands for information. When they put out a CSR report, they have liability. MB5 applies to documents, whether they're technically filed with the SEC or not. And so we should just make clear that, we're talking about there's a certain baseline already. And then the question is, what, if anything, are we doing with it, either up or down, as we think about rulemaking? So that's the first point I would make. The second point I would make is, there's an overall system, I alluded to it a minute ago, that we have different things we can use to try to elicit useful, reliable information. And those include private securities liability. There's also just straight up SEC enforcement liability. And then there's maybe, and certainly already is in financial space, controls, requirements about controls that produce the information, and then the possibility of assurance or audit in the case of financial statements. All of those mechanisms and others are all kind of both pushing and pulling in different ways, sometimes together and sometimes opposed, to hopefully produce useful and reliable information. I tend to think that the risk of boilerplate is real. It's absolutely played out in various ways. I will say there is some research out there suggesting even boilerplate is helpful in certain ways. But in any event, that's a reason for us to go back to where I started on what's the key trade-offs here, like how detailed to be. Like if you have a metric, then you can't respond with boilerplate to a specific metric. Tell us your scope 1 emissions. You can't have a paragraph, well, we do various things, right? It actually has to be a number. And so that's a role for specific metrics to play. I also think currently, and this goes back to evolution over time, there are things that are going to matter, scope 3, for example, or offsets, that we probably couldn't specify in any detail right now, how we want companies to think about disclosure. And so we're going to have some open-ended aspects. In addition, the TCFD framework, which many of you know about, if you don't, you should go look at it. It's a wonderful framework here. It is focused on things that are going to be very hard to specify with any great detail, like strategy and overall risk management. And I think the trick there is to think hard about the liability risks that you just raised. And I am completely open to different ways of treating disclosures, bearing in mind that we don't want to leave open the possibility that companies can simply lie, to put too strong a point on it. Right, there needs to be some check, but I am open to different kinds of thinking about the precise liability framework for any given disclosure of that kind.
Makes sense. And I want to just say, as an observer, rather than a policymaker at the moment, I urge the market to come in with comments on that for you, John. That's a tough balance you're trying to strike, and I think a market sense, especially from the investor side on that question, will be useful. And as a spoiler alert, on the institutional investor panel I'll be leading this afternoon, we will be discussing that in some detail. You know, John, we've got more than 200 market participants on the line. I'd be remiss not to share some of their questions. And a colleague of ours, Ed Green, is asking the following. I think it's a good question. If you impose requirements like this on publicly held companies, John, there's some risk that'll lead to more capital raising in the private market. And as it is, we have a very frothy private market capital raising landscape at the moment. You know, when I was an investment banker raising money in the late 1990s, you couldn't raise a few $1 billion privately. You had to ring the bell in New York to raise that kind of scale. Now you can raise that kind of money by making a wrong turn in San Francisco. So we're wondering, or the market's wondering, whether imposing these kinds of requirements are going to lead to more private capital raising. And how are you thinking about that trade-off?
So I do think it's a real point, and I don't want to suggest that it's not something we'll think about. Having said that, we kind of have a mission, and our mission is defined around investors in public companies primarily. And while the relative balance of private and public is certainly important to us, because we also think about capital formation as a specific feature of that mission. To some extent, if there's an investor demand for material information from a public company, then the fact that might on the margin affect the relative attractiveness, isn't usually going to be a first order determinant of how we think about it. I want to make a couple of points, though, that suggest that the strength of the point is maybe a little overstated here. First, investors in private companies through fund complexes are already also demanding ESG disclosures, at least in some areas. And so the same pension funds, mutual funds, asset managers, and so on that are buying and trading shares of public companies who are generating the demand here are also doing it down through private equity funds and other forms of private ownership. Second, banks and insurance companies with whom large private companies have to deal in order to raise basic working capital or necessary insurance also are increasingly asking for, expecting regularized, comparable, and assured ESG-related disclosures, again, at least in some of the areas that are under consideration. I don't think that a major company, even a private one like Cargill, is going to just be able to completely ignore the relevance of things like transition risk and physical risk from storms. And so you can overstate a little bit if you just focus on what we're doing as opposed to what the overall marketplace is doing.
That makes good sense, John, and I think you're right. This is always a theme of those who are skeptical of additional regulation, and it's a good question to ask, but you're right, it's important not to overstate the point. Let's turn to a subject that is near and dear to my own heart, which is the prospect of a global standard setter on questions, particularly of climate, but sustainability more generally. In the end, John, do you think there will ultimately be one global sustainability standard, such as the SSB that the IFRS Foundation is standing up? And I want to just frame the question a little bit for you by offering folks in the audience just a little bit of history. Because, John, of course, there has been a push for international financial reporting standards on the financial reporting side for decades. So far as I'm aware, the United States has not yet joined abandoned U.S. standard setting. No, instead, those standards are set through the Financial Accounting Standards Board and the Government Accounting Standards Board, both overseen by the Financial Accounting Foundation. Is it likely that the U.S. will join the international standard setter, or is another path more likely? Where are you on those developments?
So let me say, first of all, that I'm going to kind of not quite answer your first question, because I think there's an important prior question, which is there's zero interest that I've found from any quarter in having different standards applied across borders for the same topic or question. So if we're going to measure scope 1 greenhouse gas emission, there shouldn't be, a French version, the Spanish version, an English version, the Canadian version, and a US version. There should be one. And so I think, kind of regardless of the answer to your first question, I'm committed. I believe my counterparts in other countries are committed, and I actually am going to be trying my best to get some more formality to that commitment to avoid variation at the technical level. That's not going to determine necessarily that we all have the same disclosure requirements, but it will mean that at least where we do have a similar requirement, it'll be measured, validated, and assured in the same way. And that's a little different from a financial accounting, where we have, in a sense, the luxury right now of being able to make that kind of commitment up front before the at least public mandate versions of ESG disclosure begin to be considered, say, in the EC. They just passed a law equivalent to a law there, but they haven't gotten to the actual rulemaking. Same with IFRS, and we're obviously not yet into the details of rulemaking either. So I hope that, regardless of the answer to your actual question, that we can end up with something that is as close to a convergent global set of standards as one can reasonably expect. I will note in passing that different countries have different contexts. So let's take political disclosure for a second, which is not, necessarily the focus of some people in this area, but it is an area that I know you care about and I care about. Different countries have different ways of funding elections. Mm-hmm. So it's unlikely that that issue will resonate exactly in the same way across national borders. So I think there will probably not be a single overall exactly equivalent ESG standard regardless of issue. Same for labor. And it's just different labor laws. And so it's going to make different kinds of ESG topics a little bit different country to country. Having said that, I do hope very much at the technical level, we can get convergence. And at the top level, we are at the SEC working through IOSCO to help evaluate the Alliance. This is a group of private standard setters. They have a prototype in the climate space to see if that could be incorporated. We are working through IOSCO to support the IFRS Foundation's efforts to develop the SSB. And we certainly are open-minded about the possibility of embracing a single standard setter. That really is your question. But I will then note, there are very important challenges I've already mentioned about governance and funding that would have to be worked through before we could actually commit to that.
Just as a hypothetical idea, John, is it me or might it be helpful if the governance, funding, and other challenges required that there be a U.S. standard setter, might it be helpful for there to be some formal understanding as among any U.S. standard setter with international ones about the need for convergence? Because I quite agree with you. I doubt many market participants on this line are interested in having 6 different standards across the globe for certain disclosure topics.
You're thinking exactly along the same lines, and we didn't work this up ahead of time for the folks in the audience. Let me describe a little bit, very briefly. My current authority is me, and I'm saying publicly what you just heard me say. So that's the first step towards, I hope, a commitment to convergence at the ground level on technical measurement. I'm having conversations with my counterparts elsewhere where I'm hoping we can get, just at the staff level, a more general commitment, either in speeches or in a document. We'll see. And then ideally we get it moved all the way up to make it actually fully authoritative in some way. I think there will be, again, a need to, recognize the possible need for exceptions, because, again, not every country is going to approach this topic in the same way, but at least where we are trying to require disclosure of the same thing, I can't frankly imagine why any of us have an interest in doing it differently.
I quite agree. Makes sense. Relatedly, let's turn to the subject of materiality. Because John, I have to tell you, when you taught me materiality so many years ago, I must have missed the part on double materiality, dynamic materiality, enterprise materiality. I look back at my outline, man, I didn't see that. Is it realistic to expect there can be a harmonized set of standards when we've got such different concepts with really such different background, John? After all, I mean, the materiality concepts come from the long history of common law fraud from which many security standards are drawn. Is it realistic to think we can get to harmonization with so many different concepts of materiality underlying the disclosures in different jurisdictions?
So, my lectures were incomplete on this, obviously. Here's what I'd say about all of that. The first thing I want to say is I think it's a whole lot easier to have an argument, and frankly, of an academic kind, no offense to my former self and everyone on this call, about concepts of materiality than it actually is to have an argument about whether Scope 1 greenhouse gas emissions is in fact material, however you understand materiality. Right? I think right now, it doesn't matter how you think about materiality, it's priced already in the capital markets. So if it's priced in the capital markets, it's going to be double materiality material. And so that's an example of how I think we can let kind of the conceptual part of it get in the way of getting something practical done. I'm all in favor of practicality. So another example that's a little different is materiality has always been, however you think about it, dynamic. And so asbestos is the example I've used in other settings. For those of you who haven't heard it, at one point in time, whether a company used or employed asbestos in its activities was non-financial, it's just like an input to what it did. Later, it became obviously a risk, and it then became actually a contingent liability. Then it became a real liability on the balance sheet, and then it became a bankrupting event for an entire set of industries. That process of something starting out at one end and becoming all the way on, all the way through, I think is something that we're going through right now. I don't have a crystal ball. I can't be sure where it's all going to end up, but I do think conventional investor-oriented materiality has always been dynamic, and has always had next to it, risk factors that, or MD&A kind of thinking that anticipates the possibility of negative externalities getting pulled into the financial statements over time. And if you think about what the differences are really when people fight at the conceptual level, it is not whether something is important in some general sense, it's whether they're currently bookable or currently likely in imminent sense to be pulled into the financials. So it's just a question of timing. And I'm not saying that's not nothing, but I just think we can end up having a whole lot more room for agreement on these topics than people seem to think.
Those points are well taken, John. I want to add a little bit of editorializing of my own, which was one thing that was notable to me on the commission is that folks in the market seem to have forgotten that the materiality examination is, of course, not about importance to corporate counsel or corporate insiders, but instead to investors. In fact, a division director, before stepping down at the end of the Trump administration, made the argument that materiality has always been issuer determined. And I thought it was important to point out that's just not the law. That's been wrong forever. The Supreme Court has always referred to importance of matters to investors, certainly with respect to climate. It's very hard to debate that the issue is important to investors. So these are reasons why, even in an investor-focused framework, one could be comfortable with materiality of climate-related subjects. In all events, let's turn to another topic, which is the 2010 guidance the Commission issued on climate change disclosures. Do you expect the Commission's likely to update that guidance, or are you more likely to move directly to rulemaking? A lot's happened since 2010. I must tell you, my own reaction as an academic and market participant was that the 2010 guidance was not groundbreaking, nor did it lead to enormously helpful insights in disclosures. Is it time to update that, or are you going to move right to rulemaking, John? What do you think?
I don't really know, Rob. I think at a minimum, I think we may very well, and maybe even relatively soon, do some staff level updating of a modest kind, which would be to reflect developments in the world and to remind companies that as they prepare their disclosures in response to the 2010 guidance, that things have happened, including, most recently, our current president's commitments to transform the economy and cut U.S. greenhouse gas emissions by 50% by 2030. Even if you discount for political feasibility, there's clearly a new commitment at the top level of the administration to change the way in which energy is produced and consumed up and down the supply chain. And so at a minimum, companies need to be keeping up to date on events like that. That's in the broad bucket of what is referred to in this area as transition risk. And that is something that in effect was referred to in the 2010 guidance, but it's not clear to me that companies all are consistently keeping up to date on ground level facts related to the guidance. So that's an area where I could imagine we probably will do some modest updating. Implicit in your question though is, should we just go ahead and do some rulemaking? And I do think a rulemaking piece is going to be on the agenda, and so that then may make updating the guidance in a formal sense less pressing. I want to also, in this context, note materiality is used, of course, in that guidance. It's used in MD&A more generally. It's used throughout our rules. And I just say one other word about materiality. I think it's very important to remember that we've never limited every disclosable item by overall materiality, however measured. We have a whole variety of disclosure requirements that admittedly are about a material topic, but as applied, clearly trigger disclosures that are not individually material for a given company for the component disclosures. Here's an example. Related party transactions has a specific dollar threshold of $120,000. I think if you do the math against JP Morgan, that's a pretty small number. That's a pretty, it's 0.0, I don't know how many zeros, but a bunch of zeros. And so we require that anyway. And we do that because of qualitative features of the importance of conflicts to assessing governance, which, is material as a whole. But that's just an example of how, now there is actually a materiality qualifier in that disclosure requirement, but it's material to the individual.
Right.
And that's another way in which materiality kind of comes into our rules. And I think a lot of times people don't keep track of it. They just talk at a very high level and say, well, everything has to be material and how we define material. But actually, that's not right. We identify topic areas, and then we set up a disclosure system within it. And not everything within that is tested against the highest level of materiality.
That's very helpful, John. And, my own impression during my time on the commission is that folks have grown rather imprecise about their thinking on materiality. And one way is in this way. Your example of RPTs rather is very interesting. Of course, there's a separate statutory authorization. That's the Sarbanes-Oxley statute, I think. But there are other contexts in which there's no separate statutory authorization, but your division mandates extensive disclosure. Another example might be executive pay, where perquisites over, I think, $25,000 are subject to disclosure. And as I think you would say there, that's a topic that is material to investors generally, even if that particular disclosure might not be. That particular $27,000 perquisite might not be material in the broadest financial sense, right?
Yeah, another one would be stock buybacks, where we require you buy back one share, you got to say that. Not material in a general sense to the financials of that company, but the overall topic of buybacks is one that is material. So I just flag that because I think as we go through the rulemaking process or the guidance updating, people may have a tendency to focus at the wrong level. And I just, if we can agree that, let's say, the ending of the Earth because climate change produces an uninhabitable planet is material, Okay, that's one established fact. Is the contribution of companies overall in a given industry material to that? That's another level of materiality. Is the investment that people have made or about to make in those companies materially connected to the risks associated with that material factor? That's another level. Then we get down to, all right, is this particular disclosable item material for that particular company at any point in time? Not necessarily. And so if the overall disclosure regime is anchored in basic materiality, then I think there's always been flexibility in how we specify the requirements.
It's a very important point. And John, we've only got a little less than 10 minutes left, so I'd be remiss not to ask you this question. I know folks in the market are wondering about that, and we've got some questions from our participants about it this morning. Some of the most vocal calls for more disclosure in this area have been the largest asset managers and banks who have said that more disclosure on this front would make their risk management task, would help deepen their risk management analysis. How are you thinking about how any rules you develop will satisfy their informational needs? Is that a potentially important consumer of the rules you're thinking about now?
Yes, we're in regular dialogue with bank regulators and banks themselves, insurance regulators and insurance companies. Asset managers obviously are leading the charge in many ways here, and we directly oversee them. And I would just note too that Europe started with asset management, right? I mean, they kind of started with the end user of the information and then established what was necessary for that, and then have been rolling back towards the company. We too have kind of the same dynamic where the users of the information, not only investors, but lenders and insurers, are pushing up the chain to get better information. They're doing it somewhat privately, but they're also doing it through the public reporting process. And I just one other point I want to make, look back to cost benefit. Another part of the baseline, just to remind everybody, is investors are effectively demanding, and it's not really please do, it's give us information. And so when we think about our rulemaking process, the benchmark is like, what is the cost the company's already incurring? I think we actually can save some costs in the form of reducing the differences in how the information is reported and packaged. And I think that's particularly going to be important for small and medium-sized companies who are increasingly the target of some of the ESG asks.
That makes a lot of sense. And our friend Bob Mannheim has shared a question on a subject we haven't gotten to, John, that I think that we should, which is disclosure related to questions around diversity and inclusion. Obviously, among the most pressing social questions in the nation at the moment, and for very good reason, and a question that's on the mind of a lot of investors, John. Among other things, NASDAQ, of course, has offered a proposal related to disclosure on the subject. Can you say a little bit about what the Division of Corporation Finance might be thinking of offering issuers and guidance on that subject?
Sure. To remind everybody, we do have a line item already on diversity at the board level. We also have oversight of the shareholder proposal process, and there have been a steady flow, an increased flow of proposals about diversity disclosure, which have been allowed to be presented despite efforts to keep them out through the no action process. Beyond that, I'm quite convinced from good research coming out of, and I'm going to praise a peer institution, NYU, Wharton, and other places that establish that diversity is a significant component of group functioning and efficacy. And that includes gender. It also includes demographic diversity more broadly. It includes expertise diversity. And so I think responsible governance for at least a decade has included a real commitment to diversity at the best run public companies. And that gives you a sense of my view about the materiality of those topics. If they're expending, as they are, significant resources in thinking about measuring, reporting, rewarding, and incentivizing, and ultimately changing their diversity inclusion practices, that tells me that the best seated, first front row people are on board on the idea that diversity is material to outcomes. for companies and therefore for investors. And then likewise, as you note, investors themselves are demanding change in these practices as well. So that all goes into my thinking. Exactly the way that we do it, I think, is still to be worked out. It's something of a distinct topic, say, from climate, although obviously it certainly is connected to human capital, which is another area that we're looking at very, very closely.
Well, right. And of course, Gary Genser's predecessor, Jay Clayton, did include some detail on human capital management in a revision to some of the disclosure items. Can you say a little bit about the division's current thinking about human capital management questions?
Yes, I would say that looking, at a first pass at the disclosures that have been coming in, there's quite a range of variation. There are, I will tell you, some companies that don't seem to have noticed the rule change, and we will be having comments. If they're just reporting full-time employees, which is the old rule, and that's it, then they're not following the new rule. There are, at the other extreme, companies that have been incredibly thoughtful and responsible about laying out a full range of both qualitative and quantitative information useful for investors to evaluate the value formation they're getting. And I'll just note in passing that, intangibles, which this is a subset of, has been, I think, I'll look at April here in theory and get her to nod or not in the vacuum, increasingly relevant to earnings over time, to value creation, and so on. And so I think we certainly will be looking at the range of quantitative information that's been disclosed this year and assessing whether or not there are elements of that that could be used to augment last year's change. And there may be more other qualitative features as well.
John, it's almost like providing only principles-based disclosure might have left issuers an undesirable degree of flexibility that gave you too much variation and not so much help in the details of the disclosure. I feel like one of the commissioners said that at the time.
I'm wondering who that might be.
Yeah.
Look, let me say a word about principles. Look, principles are absolutely crucial because if you just require specific things, it's like having a speed limit with no flexibility to adjust for rain, nighttime, dangerous pedestrian activity. We need reckless driving as a complement to speed limits. But the reverse is also true. If you just have a loose standard like reckless driving, you're going to get a lot of behavior that's a lot harder to control, a lot harder to compare, a lot harder to evaluate, and a lot harder to provide feedback on. And so I've never understood, frankly, principles versus something else. To me, they always have to work together. Specifics and metrics. There's no legal system, no accounting system, no rule system that I'm aware of that doesn't include both.
Yeah, and I often felt sometimes in the prior circumstance and the prior commission that if we could, we would have promulgated a principles-based balance sheet. Everyone likes principles, of course, but accountability and consistency, I think, are also valued in the market. And with that in mind, John, I'd be remiss not to turn to April Klein's panel, which will discuss several of the accounting issues you and I have been digging into. But first, ladies and gentlemen, please join me in thanking my teacher, our graduate, John Coates, the director of the Division of Corporation Finance. John, thank you for your service, for the great work you're doing at the division, and of course, for your comments this morning. Thanks again, John. And we hope you would go ahead.
Just very happy to be here. And let me just say, for the folks who sent in questions that we didn't get to, put them in the comment file, send them in, or reach out to me separately and we can have a chat. I'd be happy to engage with you. Thanks, guys.
Thank you, John. Be well. We'll turn now to our second panel. Will be led by my colleague and friend, April Klein, who along with Ed Rock and I at the Institute for Corporate Governance and Finance, the Ross Institute for Accounting Research has been our partner in launching today's event. In April, we are very grateful for that partnership. And I'm looking forward to the insights you're going to provide from finance. You have a tremendous panel full of researchers who are at the cutting edge of these questions. And I'm looking forward to the conversation. Please take it away.
Okay, thank you. Thank you, Rob, and John as well. Your conversation really teed up, I think, a lot of things that we're going to be talking about today. In particular, John, he mentioned two things. He spoke of useful information and he spoke about reliable information. And that's exactly what we'll be talking about today. I think the first half will talk about usefulness, and the second half will be talking about reliability. I have a great panel here today. Unfortunately, George Serafine is unable to join us. But in alphabetical order, just let me give a very brief introduction to each of the other four people. Full bios of the people are on the Ross website if you're interested in more information. So in alphabetical order. So first we have Sarah DeSmith. So Sarah is a partner in PwC's Digital Assurance and Transparency practice. She leads their ESG assurance practice, which provides both consulting on ESG issues and auditing of ESG reports for client firms. So certainly talking about reliability, I think Sarah is going to be, she's going to be able to tell us so much about what PwC does and the costs of these particular audits, and certainly how are we going to get this reliable information. Marcin Kaspacek, he is a professor of finance at Imperial College Business School in London. We do know Marcin because he spent several years at NYU in the finance department. Marcin has written extensively on climate change risk. And this is, I think, where the usefulness is going to come in, because there's so much conventional wisdom out there as to what information is useful, what information is not. And what academics do, and particularly empirical academics do, we take very large bodies of data, many companies, many different types of, like I said, the data type things out there. We try to control for all other things that possibly could be explaining the particular data. And then we say, well, does A give us B? And that's the type of information that we'll be doing today. And Marcin is going to talk quite a lot about what type of things of climate risk, scope 1, scope 2, scope 3, for example, what is the market interested in? Christian Leitz. Christian is the Joseph Steinheimer Professor of International Economics, Finance, and Accounting. So Christian covers everything, okay? He's at the University of Chicago's Booth School of Business. His research encompasses many areas, but most notably for today, he's done an extensive amount of work on disclosure and transparency in capital markets. He's also an author of a seminal paper on international accounting standards. And again, John and Rob, you really teed this up very well for me because we do want to talk a bit about the harmonization of the U.S. with the international markets. And then the last person is Lucrezia Reichland. She's professor of economics at the London Business School. Lucrezia is currently the chair of the European Corporate Governance Institute, the ECGI, which has an enormous research agenda dealing with ESG. And I strongly suggest, people just go on their website and you could just pull paper after paper after paper. And she also is a trustee of the International Financial Reporting Standards, we call it IFRS Foundation. I'd like to say Lucrezia is very well trained because she has a PhD in economics from NYU. She is a macroeconomist, and one of my colleagues referred to her as a Nouriel Roubini of Europe. And for people who know Nouriel, I have to say this was said in the most admiring way. Okay, so anyway, I thank everyone for coming and welcome for being here. So let's begin by talking about the ESG disclosures and how they're used by the market, right? So this is going to be the usefulness of the information. So Christian, let me start by asking you, okay? So you have two very extensive survey papers on issues that deal with ESG disclosures. One is on mandatory disclosure, which I will ask you to talk about a little later on. But you also have one that just talks about how ESG is used by market participants. So can you just describe some of this literature and just tell us how ESG disclosures, in fact, are used by investors? Because that's what the SEC is most interested in, right? The SEC is, in a sense, the oversight for investors. So can you just tell us, how is these ESG disclosures used and whether the market even cares about these types of disclosures?
Yeah. So first of all, good morning, everybody, and pleased to be here. Thanks for having me on the panel. It's a great honor. So as to your question, so it's actually one survey paper that we looked at that morphed over time, and at this point focuses a bit more on the mandatory question because That's what the key question is today, but we can make that available to participants. The ESG disclosures are used by investors sort of in a myriad of ways, and the standard way in which we test whether investors use disclosures in research is to look how capital markets price this information, how they react to this information. We perform tests with other capital market variables like liquidity, portfolio adjustments, and so on. And so there we actually have a lot of research on this question, and we're trying to collate that in that review. Based on that, I'm pretty confident to say that ESG disclosures provide new information. So if this is something that the market didn't previously have, that investors would respond, and the capital markets respond sort of in the way they respond to other new information, right? So what I mean by that is ESG in that regard is not different from other information. That is, better information would tend to improve liquidity, can lower the cost of capital. So the evidence that we have would suggest that ESG information can be material and decision relevant to investors. But one of the things I want to point out about the research that's tricky is that it often doesn't differentiate between, are we talking about the effects of the information, so the quality of the information, the type of the information, or are we talking about the underlying ESG activities and risks? And those are two slightly different things. And I think Marcin will talk probably a bit more about the pricing of these risks. But my sense of the evidence there is, again, that we have a fair bit of evidence that would suggest that ESG risks and activities are priced. So take carbon risk, right? It is, and by priced, I mean it's reflected in the firm's valuations. It's very hard to know if it's sufficiently reflected, but I think we have evidence that it is reflected. Now, John Coates mentioned in his earlier discussion that the cost of capital is pretty important. And here, I think there's sort of two ways in which the ESG activities and risks can be priced. One way in which they're priced is as a non-diversifiable risk exposure. So if a firm is more susceptible to ESG shocks, then investors can't diversify, then that would mean they have a higher cost of capital. The other way in which they could be priced is through preferences, right? So if investors have non-financial, say, green preferences, they might accept a lower cost of capital for holding green stocks. And those two forces pull in opposite directions. And so that makes it a little tricky. And what makes it even trickier for researchers to figure out exactly how these things are priced at the moment is that these preferences have been shifting. And so what we see at the moment is that because the preferences have been shifting, a lot of the green stocks have higher returns as investors move into them. But in the long run, the preference channel would actually mean that they should have lower returns. So now to just close out your question, coming back to the information, given the pricing of these ESG exposures and preferences, I would say that it's clear that information about the firm's activities in the ESG space, their exposures, matter, because that helps investors either to find stocks that match their preferences or helps them to sort of price these risks as we see that they're already doing.
Okay, so Kristen, just to follow up a little bit. So when I look at like BlackRock, or I look at Vanguard, or when they come up with their statements, and they talk about ESG and not only just climate, but let's say diversity, whatever, they usually talk about it being like long run performance or long term performance. But on the other side, I think we're also talking about risk, right? So in most of the studies that you look at or which you're aware of, are people like investors, are they seeing ESG more as like performance drivers, or are they seeing it more as risk drivers? Are they afraid of like black swan risk? Are they do you have a feel for the type of information? I know you mentioned that we look at very broad information.
I think there's two, I think it's probably a little bit of both, in the sense that first, it's fairly clear that there is a risk component, that people are thinking about the transition risk or cliff risk related to the climate regulation that is coming, or the climate change implying that there's certain physical risks be it in related to assets that the firms have. So that is, I think, clearly one component. The other component, there is a performance component, and there is quite a bit of work on what can we say about the link of ESG and performance. There is a huge meta study on this question. They typically would look at firm performance, so things like ROA, profitability in the company. That study on average finds a slight positive effect between sort of measures of good ESG or CSR and performance. But what is really tricky about that is a lot of these underlying activities are voluntarily chosen. So it's very difficult in my mind to causally attribute anything about the ESG and the CSR to the performance. So in my mind, this notion of that you can do well by doing good, the research on that, as far as I can tell, is still sort of somewhat inconclusive.
Okay, so I think we'll bring that up a little later when we talk about mandatory versus voluntary disclosure and what are the advantages and disadvantages of both. So Martin, Christian gave you a really nice lead in here to talk about some of the research which you have done. So could you just tell us a little bit about your research on dealing with climate change?
Absolutely. And first of all, I wanted to thank you, April, and everyone involved in this wonderful conference to make me be part of it. It's a pleasure to be part of this panel. And maybe in a slightly non-standard way, how usually panels are done, I did actually prepare a few slides that I wanted to show you, mostly because I think, as Mr. Coates has actually very nicely articulated, some of this discussion requires a little bit more detail and kind of quantification in the way how we want to think about these questions related to disclosure, etc. So the comments I'm going to make are going to be fairly brief, but largely subjective because they are based on the work I've done with a colleague of mine, Patrick Bolton. At the same time, I don't think they should be particularly controversial, at least on some level. So, and I hopefully that's going to also spearhead additional discussion after I finish. So I want to start with this picture. I think this picture is really important because it kind of tells us why we are here, because we are talking about disclosure. But I think what's important to understand is why is disclosure actually so important for us to think about. And what this picture is showing you is basically a simulation that tells you what it is that has to happen with global emissions worldwide so that we can achieve some kind of trajectory of temperature increase in the world. And I think to scientists, and that has been actually articulated very loudly, what we tend to now recognize is that if we go beyond 1.5 Celsius increase in temperature relative to the pre-industrial averages, we are going to be actually subject to potential existential threats. And I think this is becoming more and more of a certain statement rather than just something subject to a debate. And what this picture shows you that if you want to actually achieve that particular level of increase in temperature, what you actually need to enforce is that the global emissions worldwide go to zero effectively by about 2050, 2060. So in this regard, where I think disclosure becomes extremely important is that we actually need to see what is happening in that space, because the horizon here is actually very important. And I want to start with that monitoring aspect of disclosure that actually it provides is very helpful to think about this global question, which is, are we actually working towards something which is pretty much essential and should not be even debated to begin with? So some of the research that I have done over the last couple of years has tried to understand, do we actually observe some kind of effects that are associated with disclosure? And I hear we are going to go to the discussion between voluntary and mandatory disclosure. But what I want to say is that in the work I've done, I've kind of tried to look at both and try to see at a more kind of a global level of the international data, to what extent we can actually understand the implications of carbon disclosure for financial markets. And I think this is important because this is going to inform our discussion about the cost. It's also going to inform any kind of hardships that we are going to witness in the process of actually mandating some of these disclosures. And Christian has made this really nice observation that one of the challenges in the way how we want to understand the role of disclosure is clearly this effect of information of the disclosure event itself, relative to some kind of fundamentals. And I think one of the nice things that Patrick and I have tried to do in the work we are doing is try to actually control for the two at the same time. And the way how we are able to do it is that we have this unique data where we can actually observe some of the emission activity of the firms prior to the time when they actually disclose it to the public. So in this regard, we can actually try to see what's the incremental level of disclosure event conditional on a particular evolution of the fundamental. And one thing I want to also stress in the way how I want to think about carbon disclosure, and I think that's quite important for the regulator, I think as well, that unlike many other types of disclosures that we may be talking about, including ESG sphere, I think carbon is kind of nice because it's potentially harder to manipulate. All these ideas of greenwashing and thinking about some kind of moral hazard issues are potentially less as striking as they are, for example, when we talk about soft information. So in this regard, any kind of regulation that focuses on disclosure of emissions is potentially good because it deals with something which is more quantifiable and relatively more objective than some other types of disclosures that we generally have. And what I want to also summarize briefly, just in a minute, are the things that Mr. Coates referred to, which is we want to kind of understand this trade-off, the economic kind of framework that drives the disclosure decision. So briefly, we kind of have an understanding already. We are not the ones to propose that, but so that we are aware. I think clearly there are benefits of disclosures in terms of reducing adverse selection problems, reducing uncertainty, but these are more common to any type of disclosure. What I think is important from the perspective of carbon disclosure or climate-related disclosure is that we also are sending the signal to the broader society. We are kind of communicating what is the view that the company is taking actually on this important issue. And in this regard, this is very unique because unlike some other accounting information, we are talking about something which is broadly important to just more than finance audience. And of course, if you think about all these benefits of disclosure, the quick question is, why is it that not everyone is actually disclosing? And we do observe that very few companies are actually disclosing this type of information. So clearly there are some costs. And Professor Lloyd in his survey has this fantastic summary. I just want to highlight this idea of some kind of competitive environment in which information that is getting disclosed potentially has spillovers for anything else we do. And this has spillovers for economic activity, but also spillovers for some kind of political retribution channel that some basically stakeholders may take advantage of this type of information and go against the companies. So it's not obvious why companies in a nutshell should actually go to voluntary disclosure. In this regard, maybe mandatory disclosure has this additional benefit of actually improving on that particular front. And what I briefly want to tell you is a couple of facts that we found in our data and in the kind of large panel of global firms that had covered more than 14,000 firms. We had information on whether the company actually disclosed the emissions directly or whether this information was not publicly available to investors. This is the data that covers almost 15 years. So it's a fairly reasonable snapshot of the data given the salience of this particular event. And what's important here is that we are looking at disclosure of scope 1 and scope 2 emissions, which is what is actually being largely communicated in terms of carbon emissions. So here are a couple of facts that we found to kind of tie it back and move it forward. So the first thing that the question that we could ask is it actually important that we disclose this information from the perspective of companies' cost of capital? I mean, clearly this is economic kind of 101 reason. And what we do find in a pretty strong setting is that conditional on a level of fundamental, companies that switches from not disclosing to disclosing this information voluntarily is actually benefiting from a fairly significant actually reduction in the cost of capital. And one could argue that one reason could be maybe the reduction in uncertainty that Christian talked about. Another one could be maybe the signaling story that companies are actually sending something that is being rewarded by the market participants. But clearly there is a value in terms of cost of capital. What's also interesting though is that that does not come for free, in a sense that the moment the company comes public and it discloses this information, there is a reaction from various stakeholders. And here we are looking at institutional investors and the divestment activity. There is a potential cost that the disclosure in some sense legitimizes the fact. To the extent that the market may know something, not disclosing it publicly creates some kind of legal risk of actually taking a campaign against the company. The moment the company discloses this information, that kind of opens up the door. And we find it in the data that companies that do disclose, they tend to be on average divested more likely than companies that do not disclose, conditional on the same level of emissions. And then I want to talk a little bit more about this notion of uncertainty versus adverse selection and how we can compare maybe mandatory versus voluntary disclosure events. So here is this unique experiment that people in accounting have looked at before, and we are kind of taking advantage of this as well, which is this UK disclosure regulation in 2013 that mandated publicly listed companies to actually disclose information about their scope 1 and scope 2 emissions. And naturally has kind of shifted the degree of disclosure from some who already disclosed it before to those who are lagging behind. And we are trying to understand what's the relative importance of that event for the companies that have joined basically the group of disclosures. And what we found were two interesting effects. One is that the disclosure mandate generally has shifted the equilibrium towards pretty much everyone disclosing. And the benefit of this disclosure was that actually companies that joined the pack, they actually benefited in terms of reduction of uncertainty and subsequent reduction in the cost of capital. So clearly there is this uncertainty kind of reduction effect that works. But what we found also interesting is that there was this effect of signaling or adverse selection, which is we found that among the companies that joined and they actually disclosed, those which disclosed higher emissions, they actually benefited less from that disclosure. So it kind of tells you that the market interpreted it as bad types now entering the sphere, and we should not reward that particular bad behavior as much as some other behavior that is happening. So in some sense, we need to be aware of this kind of selection issues when we actually create a regulation, because it's not that the companies randomly actually enter the disclosure sphere versus not. And finally, I want to conclude with this, I think, very interesting observation. We may think about regulation at a country level as just affecting companies in that given country. What we found actually in our research is that the interesting story is that one of spillovers. The moment one country actually introduces regulation, we actually observe that other countries potentially also are reacting to that particular event. And in the context of the UK, what we found is that across the globe, on average, companies actually increase their rate of disclosure as the UK has mandated their own disclosure, even though none of these companies outside were directly affected by the regulation. And more so, what we found is that the integration of the markets with this one, with the UK one, was a main determinant for how strong these effects were. And in particular, we found that European companies, the ones outside of the UK, were actually the ones which has the highest kind of response. And to some extent, they benefited a lot in terms of this uncertainty reduction, unlike, for example, the Asian companies and North American companies, which actually had a much more muted reaction. So what I think to conclude is happening is that financial markets do value disclosure. I think there is a clear kind of notion that at least at the global level, we see the value of this in terms of cost of capital being reduced uncertainty, but we also need to understand that there are also some kind of additional signaling issues that need to be taken into consideration. So sorry for this kind of academic presentation, but I hope it was somewhat enlightening.
Okay, well, thank you much. And I'm actually going to come back and ask you some questions when we talk about mandatory versus voluntary, and basically ask you what your opinion is on that. But now I want to turn to some macro issues. So Janet Yellen just very recently, as the head of the Financial Stability Oversight Committee Council, FSOC, she recently said, I'm going to quote her, "Climate change poses a tremendous risk to financial stability." And John Cochrane, who's a senior fellow at the Hoover Institute, who has a blog called The Grumpy Economist, he responded to this, and I'll quote him, he called that nonsense. So I want to turn to Lucrezia. So as a macroeconomics, as macroeconomist on this particular issue, do you think John Cochrane is just being a grumpy economist? Or do you think that climate change, in fact, is a risk to financial stability? And if so, what should be done about that?
Well, April, well, first of all, thank you for inviting me here. But I think that there is no doubt that climate is a huge financial risk for the financial system, for the future of humanity, etc. And I think the regulators are well ahead of the game here. Central banks have already put together in an informal alliance, which is the alliance of the green network of central banks, and the Fed just joined. So it's not just a bunch of Europeans, just to make sure, has done a lot of work putting together a framework which integrates climate as in the prudential work that they're doing in regulating the financial system. So I think that from the world of central bankers, regulators, and you find a very clear voice in that direction. Since we have not very much time, and I want to be in this panel in an official capacity as an IFRS trustee, I would take my time to just tell you something about the IFRS, since we are not, the IFRS is not represented later in the panel, although Alan Beller has been my colleague trustees and vice chairman of the IFRS, and so maybe he will talk about something about us later. I think that in a lot of the things that John Coates said in the introduction, I think our work is probably important to, for those of you who don't know what we have been doing, I think it's important to discuss it here. So the IFRS was actually encouraged by the broad investors and regulators to actually try to see whether there was any room for enlarging the scope of our activity as standard setters beyond the financial. And with this informal encouragement, we actually launched a consultation, and this consultation was had an incredible number of responses. We got more than 600 responses from a broad range of stakeholders, and especially we got support from the Financial Stability Board, from the IOSCO, from the United Nations, from etc. So the regulators as well as investors and companies. So this is, I think it's a thermometer that is telling you, where the market is and where the regulators are in assessing, this question. So on that basis, then the questions that we asked in the consultation were actually, do we need global mandatory standards? And, we are a global institution, so our role would be in, setting a global standards. So do we need it? And the answer was yes, overwhelming, not like 90% of the responses. And then the second question was, who should do it? Okay, who should be the regulator? And there was quite a lot of support from the IFRS to do it for a number of reasons, which have to do with our, reputation in already established, records on financial reporting, for our governance. And I think governance here is a very important issue. We have a 3-tier structure in which, we are independent trustees, people like me, so independent people, but on top of us, there are the regulators, our monitoring board. And, we are a kind of hybrid institution, which is private and public funding. So which I think this kind of, a reflection on governance for global standard setter, I think it's very important. Now, with this background, I just wanted to tell you something about what we are doing, because it might be interesting for this audience today. Well, first of all, we were encouraged to go ahead, so we are going ahead and in forming a standard setting board, which will be global in its aspiration. And we have also set some strategic directions. So we will be investor focused, but with the focus on enterprise value. So we will, focus on information that is material to the decision of investors, lenders, and other creditors, but with an understanding that, as actually Christian was saying, the preferences of investors are shifting. And so, we have, that concept that also John Coates referred to as dynamic materiality. So the other strategic direction is we want to build on existing frameworks. I mean, it is clear that that there is a lot already. There is the TCFD, there is the work that SASB has done. That and so there is a need for consolidation. And so this is another message that we got very clearly from the respondent, that a lot is out there. There are lots of organizations, but we investors want a clear, landscape in which there would be comparability and a simpler framework. So we are engaging actually with this organization, and I hope that in the panel with SASB will talk later today, they will say something about it. So it's a very constructive work which will establish some principles, and we will provide a running start for this independent standard setter board that we are going to launch in November. And then importantly, so there is a question, why do we need global? Okay, so should the US going alone? Should Europe has already, issue a directive in which they say about, they will be they say what the standards will be and what the criteria will be. So, but actually this is a global problem. So what is the best way to achieve global standards? I mean, one way is to say, the jurisdiction which has more weight will be the standard setter. And the other way is to say, well, let's see whether we can have a framework which will accommodate the need for a common baseline of standards and for the flexibility that the jurisdictions need because of the different public policy or legal framework. So this concept of the building block is what we are building on. It's not just what we are actually discussing with the various jurisdictions, including with the US and with Europe, etc. And we hope that we will get, we already got the support for many jurisdictions, but we hope that, the articulation of this notion of the building blocks, so the global baseline and the top up, which at the jurisdictional level, which has to be related with public policy objectives, and legal issues will be convincing. We got the support from the community of the central banks for sure, both but by Yellen again recently. She mentioned this effort as the right way to go for global standards, and also Christine Lagarde for Europe. So, I'll be happy to take questions, but I wanted to take my time to make sure that I got my message across. Thank you.
Okay, well, I appreciate you. I was going to ask you more about that a little later, but I appreciate you discussing that. I may actually come back to it shortly. So this has to do really with, but by having these global standards, this really has to do with the reliability piece of the information. So I think the first half an hour, we were talking about the usefulness of the data and whether investors use it and whether it's important to cost of capital, and is it risk, is it performance? And I think generally I believe, the data out there seems to support that investors, in fact, do find this important, and that it is, in fact, priced either, like I said, either in cost of capital or even in the prices themselves of the individual securities. It's also something that seems to be very important, again, to the asset managers, and not just because I think it's a good thing, but because they do think it's important to the, the long-term viability of the firms. But the question that the SEC has, I think the SEC kind of agrees with this, at least John Coates in his statements seem to agree with this. But now the question is, there's so much data out there. And how do we make it reliable? How do we make it accurate? So I want to actually turn to Sarah, because Sarah, you are the head of the PwC Sustainability Assurance Practice. And when I look at your website, it says that you bring, and I'm going to quote again, transparency and trust to the sustainability metrics that investors and other stakeholders have. So one of the things that your group does is you do audits. There are these voluntary reports that companies come out with. And in fact, PwC is auditing them. So can you give us a brief understanding of how the accounting firm, or at least PwC, does these audits? Can you give us some ideas of cost? Because we're always interested in small firms. We don't want to put undue pressure on, or undue costs on small firms. So if you could just give us sort of an idea of, and also the type of information that you do audit, and is it hard information? Is it soft information? Just sort of give us like a general framework.
Sure. Thanks, April. So, yeah, I mean, when you talk about, there's a lot of data out there. I think one of the problems is the data is very scattershot these days. So I think about the environment that I operate in. We've got, there's a high degree of opacity because this is still a voluntary disclosure regime. So companies, there's leaders that are doing quite a lot and are starting to edge toward disclosing according to the generally accepted standards in this space. But there's a lot who are not, who are waiting on the sidelines to see either, am I really going to get hammered over the head by my biggest investor, or I'm going to sit on the sidelines and wait to see what the SEC is going to do. So we still have this high degree of opacity. For those companies that are reporting, there's a high degree of dissonance too, because they're either reporting their own bespoke measures, or they are using different types of standards that may not be comparable to other companies in their sector. And by and large, still, a lot of this data is unaudited. And when I say unaudited, I don't necessarily even mean having the independent accountants, the company's independent accountants, look at this information. Much of it is not even reviewed by the company's own internal audit function or by the CFO or the finance organization. Often when we come up and talk to and with our clients, we're dealing with the sustainability function people who may not have ever even met the CFO or the controller's organization. So there's a big disconnect between what is really what I consider investment grade quality data, high quality data, and what the market is consuming out there. So when I think about, so to answer your question, we are doing a lot of audits. I mean, many of PwC's clients I would put in sort of the leader category, and are trying to be very responsive to what has been an investor-led phenomenon here in the United States. So we, as a CPA firm here in the US, we have to apply the standards, the professional standards and the auditing standards of the American Institute of Certified Public Accountants, the AICPA. There is a robust set of auditing standards to cover non-financial measures like ESG metrics and CSR reports. And if you go looking and hunting, you can find a lot of examples out there of that type of assurance. Right now, the market demand level is at limited assurance, and I'm not going to get into the nuances, but most companies, when you publish your financial statements and file them in your 10K, your independent auditor is doing an examination, and it's reasonable assurance level. So think of that as positive assurance. ESG disclosures, because they are a little bit less mature, and these are not mandatory disclosures as yet here in the US, the market is at limited assurance, sometimes known as like the review level or negative assurance. So we would make a statement or a conclusion saying that nothing came to our attention that would cause us to believe that these measures are not materially fairly stated in all material senses. So our reporting tends to be in our limited assurance reports are on a metric by metric basis. So companies, what they will do is make a management assertion statement, which very clearly says management has selected these metrics because we believe that they are important and material to our company. It describes the criteria of how they've disclosed, how they've constructed that metric. And then that's what our independent assurance report covers, is management's assertion. And then that is a public use report that can be attached to the CSR report. Our companies post it on their website, wherever they talk about their ESG measures that they want to, put out to the capital markets, that, not only do we stand behind these as a company, but we've had our independent accountants come in and issue an assurance report over our measures. So when I think about where we need to get to, when I said today we're at a high degree of opacity, high degree of dissonance, and a lack of trust, because much of this is unexamined or unaudited. How do we get to where we need to be when we know that markets operate efficiently with high quality decision useful information? That's going to come as a result of, disclosures that are constructed using generally accepted standards that have been developed under a strong governance process, that have been well vetted with stakeholders, and that are understandable by not only companies having to apply those standards, but by investors who recognize and recognize that these are generally accepted standards that can be used to compare companies within sectors and across sectors. So when you get to that level of quality, and you layer on top of that not only management's oversight and governance over those disclosures, and I would say that best practice for companies is to put your ESG disclosures through the same sort of disclosure committee level review that you do the financial statements. When that happens, and you have your independent auditor coming in and doing independent assurance over those measures, that's when you really get to that high quality decision useful information. And that's when we're really going to see this kind of investing really take off. Not that we haven't already seen it take off. That's really what my clients have been responding to, is the huge amounts of capital flows that have been coming into these ESG investment structures here in the US. And I'll just use this as an example. Right now, investors, the biggest asset managers here in the US, are very much relying on the ratings agencies, the key ratings agencies in this space, to help them pick the winners and the losers, because there isn't that level of high quality decision useful information out there. So the ratings agencies are publicly scraping everything that's publicly available from companies and trying to make sense and synthesize the disclosures as they stand right now and help the big asset managers and investors pick the winners and the losers. So right now, companies are looking to those ratings agencies to try to understand, okay, well, what are they looking for? What do I have to do in order to get to a good enough rating to be included in the indices that are going to be licensed out to these big asset managers? I don't think that that's a dynamic that can continue for the long term. What we really need to move to is much more consistent, high quality, standardized disclosures, so that investors can make those decisions themselves and not be relying so heavily on ratings agencies. So
Yes.
maybe I'll pause there.
You see, you really brought up two really, I think, key points. One has to do whether we should be mandatory versus voluntary. And then the other one is, should there be, who should make up the standards? For example, and Lucas, I'll come to you in a moment, I promise. Should there be a harmonization, for example? In other words, should the standards be around? Or, John Coates earlier, he was talking about how, different countries have different laws or even different ways of looking at things. So let's begin by talking about it. It's a little easier and a little less political. So let's just talk about mandatory versus voluntary, right? So Christian, could you weigh in on that? And then Martin, I'm going to ask you to weigh in a little bit on that as well. So Christian, can you talk about, do you think it should be mandatory? Do you think it should be voluntary? And more importantly, what does the academic literature tell us on this?
Yeah, so sure. I think it's a big question. There are quite a few things that we can say, and we know from the accounting and finance research on this question. I mean, we can't sort of summarize all the pros and cons in the short time that we have. This was kind of the motivating question for the paper that I mentioned, but let me say a few high-level things that speak to that question. First, I would say what you consider sort of pro or a con depends a lot on the goal that you have in mind for the mandate and how you come out also on the current state of reporting. So let me explain. as mentioned earlier, we discussed investors, demand this information, they respond to ESG information. So a critical question is therefore, in my mind, to what extent do we believe that firms currently provide or do not provide ESG information that is material to investors? If they mostly provide the material information, then additional disclosures that they want to make is kind of icing on the cake. And from that perspective, the current SEC regime is probably doing its job, and voluntary disclosure on top of that would be fine. But if we believe that maybe not all of the material information that investors demand in this ESG space is necessarily provided by companies, and the recent demands and some of the complaints from investors that we've talked about would be consistent with that, then the problem is likely that it's often not clear what is material. And to some extent, we should look at this problem also from the perspective of it being more of a compliance issue, right? In that case, voluntary disclosures, in my mind, won't work. In this case, we need the standards to clarify what is actually material so that, companies wouldn't be able to sort of just provide sort of a high level boilerplate disclosure. We need to sort of address the compliance problem if there is one. And what I'm saying is sort of consistent with what John Coates was saying earlier, is that the SEC regime is very clear in that regard. It's not making a distinction between some information as financial and other information is in the ESG spaces. In general, the question is the information material? So if we're talking about ESG information that is financial and material to investors, then I think the case for mandatory CSR or ESG reporting standards can be made. And the reason is that the SEC disclosure framework that we have is already based on material information to investors. And as I said, it doesn't matter whether that's financial, ESG, or D&I information. The normative question on should firms provide this information that is material to investors has already been made. The framework kind of applies. But as also Lucrezia was sort of referring to, it's also clear that at least some investors, and increasingly so, have preferences and would like to have information that goes beyond sort of what's financially material, right? So they might not just be maximizing their own wealth, they might also think about the company's impact on the environment and the society. They care about the externalities that companies might be causing. And externalities is a good example where almost by definition, it's not clear that they're financially material to the company right now. It's otherwise they wouldn't be an externality, right? And so in the same kind of demand is coming from other stakeholders. Now here, the goal of ESG reporting now shifts. Now it becomes sort of about driving change in firm behavior. And this is sort of where Marcin's presentation was going when he started out and said, look, there's this big, climate problem that we're trying to address through disclosure. Now, again, if that's your goal, if you're trying to change behavior and trying to address the climate goal, then again, I don't think voluntary disclosure is likely to work. But I will also say that the case for the mandate becomes more complicated too, because we know that firms adjust their behavior when we force them to provide information. So it's not just that the receivers of this information, like Marcin's work shows, works, or respond, like the cost of capital maybe, and the pricing in the markets. But the firms also respond to these responses and what we, as economists, call these real effects, right? In the firm responses, or these real effects, they can be intended. So when we think about shareholder monitoring, we think in providing information to the shareholders helps them monitor and align the firm's behavior with what investors want or the shareholders want the firm to do. In the ESG space, you could see how ESG would maybe lead to a reduction in pollution or CO2 emissions. But there's also potentially a lot of unintended consequences. And so that is, I think, what is tricky. Involuntary disclosure would be less likely to trigger these unintended consequences. And so here, I think there's a sort of a clear trade-off that we know from the disclosure literature and so on. And then furthermore, and this is the last point I want to make, if we mandate ESG reporting to facilitate or drive change, in corporate behavior, then in a way that ESG reporting mandate becomes closer to other regulation that restricts or limits corporate behavior, taxes corporate behavior. And for such regulation, we typically require some form of democratic legitimization, right? So that is sort of a question: is sort of the reporting framework the right way to do it, an important question then is who gets to decide, what change we're driving. Now, in the case of clear externalities like the CO2 emissions, and especially if we lack other tools, like for instance, if we rule out a Pigouvian tax, like a carbon tax, if we rule that out, then it can make sense to say maybe the reporting regulation is one of the things we should be using to help internalize the external effects. That's going to impose some penalties on companies, and that's an intended effect that we want. But we should at the same time be very well aware that there's also lots of evidence how these disclosure regimes could have unintended consequences. And I think that's a key challenge for the SEC to think about. How do you trade these things off?
Okay, that's a very interesting observation, because we certainly see that in accounting, right? When you come out with a new accounting standard and taxes is a really even better example, right? How companies will change their behavior, right? In order to, comply or not comply, with the new disclosure requirements. So Lucrezia, we only have a few minutes left. So, John Coates seemed, but he's not a commissioner, right? But John Coates seemed to be very in favor of having some type of a harmonization, and certainly having the IFRS and the SEC come together. But very recently, there was another SEC commissioner, Hester Pierce, and she's particularly said that she did not support having a worldwide set of standards. So I was just wondering what the IFRS position officially was, or even not officially was, on working with the SEC, and also what arguments you can give to people who may argue that there are such differences and maybe we should not have a particular harmonization.
Well, first of all, let me say that the FRS is not, is not trying to push this agenda. I mean, I think we responded to a consultation, and so we are trying to, set up a system which is legitimate for achieving global standards. There are difficult questions, and I totally agree in the way in which Christian set it up. Okay, so that what is material to companies, to financial material to companies, in any way we already have it. Okay, so that and you could argue that the FRS is already doing the standard. I mean, not for the US, but for 150 countries in the world on the financial. Okay. The problem is that, there is an externality when we're talking about climate, and therefore what is material is also related to, what companies do to the environment and vice versa. And also, what is the value, the enterprise value, which is our concept. It is something that, is not that clearly defined, okay? The horizon is not defined, and so on and so forth. Okay, so coming to so it is inevitable, and then there is, just let me finish with the premise, and then there is this other thing that you may want to have standards because you want to achieve some goals. Okay, which is, I don't know, goals which are embedded in your legislation and so on. Now, a standard setter like us would not be legitimate to do that. But the US may want to do, something, within, the climate policy, like, for example, the EU is doing. So standards are integrated to, a broader set of policies. So what we are saying to the EU and to the US is that, of course, we are not a legitimate organization to, achieve that goal, but we are the legitimate organization to define a global baseline, which would be important for investors, especially investors which operate globally, so that whatever countries want to do on top of that for other objectives that they may have, it will be on top of something which is agreed and shared. So I think that would actually, respond to the problem that that was mentioned before, that actually, there are too many standards, and the rating agency have a bigger role because it's not clear who set the standards. There are many organizations. So we need, to the extent in which everybody agrees that there should be some kind of global consolidation, global baseline, I'm quite confident that the US will be on board in some ways, okay? Maybe with a contractual arrangement or maybe joining the FRS, I don't know. This is not my, it's not my place to say that, okay? I understand from the speeches that different board members of the SEC have given that not everybody's on the same, has the same idea on that. So we are engaging with them, trying to understand, how we can be constructive. That's all.
Okay, so we only have a couple of minutes left. So let me just start a very open question, and whoever wants to pop in, feel free. What advice would you give to the SEC? The SEC is moving forward on something that seems to be. It's very big. There's messy data out there. We don't really know how or what was the SEC is. To what degree the SEC is supposed to mandate things. Should we have a setter? An international setter, a local setter? If you had to give one piece of advice to the SEC, as where you're sitting, what would it be? So, Marcia, let me begin with you.
Yeah, I just want to make one point, which I think is maybe a bigger picture point, but I think it's critical. We are not in the world where time is infinity. And I think this statement that Carney has made about tragedy of the horizon, I think is really the most important aspect. So if I could give one advice is be quick. Whatever you think gives you the gut feeling is going to work, you should be implementing it now, not in the future. So any kind of use of future tense and any kind of deliberation, should we do this or that, it's just going to make things more and more difficult. And I think people need to realize it. So even if you overshoot, even if you undershoot, I think it's better than do nothing right now, which I think is critical.
It's excellent advice. Christian?
Let me sort of say, I think if I've learned one of the things, it's a very complex issue. And so I would say first, let's be clear about the goals. Like, I think depending on what goal you have in mind, if you have Marcin's goal in mind, and if that's the primary thing, then I think you come out very differently than if you say all we're trying to address with the SEC regime is primarily issues with regard to financially material information to investors. I completely agree with the sense of urgency, but given the complexity of the matter, I would say I agree with the rush in some areas, but it might make sense then to also focus on the matters where we face the irreversibility issues, right? Like the climate, the biodiversity that Marcin pointed out. There we don't have a lot of time. Maybe the good thing would be to build a framework for those to learn and then sort of broaden out. And then the final issue, and that might tee it up for Sarah, because I liked her comments a lot, is spend a lot of time thinking about assurance and enforcement from the beginning. All too often, we spend all the time discussing the standards, but not enough time on how are we going to implement them and how we're going to enforce them. And there's a ton of research that supports that adequate enforcement is really central to the success of the standards.
Excellent.
Thanks for teeing that up, Christian.
Sarah?
Yeah, I would just say, and I couldn't agree more with what Christian said. I'll weigh in on the global set of standards. I mean, the capital markets are global. Companies operate globally. There's just no sense in trying to come up with something unique for the US or something unique for the European Commission. I think the IFRS effort and their new Sustainability Standards Board is the right way to go. And time is of the essence. I completely agree with that. So take the best of what's already out there and what is working for companies and for investors and build from there.
Okay, and Lucrezia, last word.
Yes, I think timing is important for climate for sure. And we are taking that seriously. So we are going to announce this board in November, and whoever is going to be on board,
Okay, well, I want to thank everybody. I think this has been a great panel. So much information. It's unusual to have, I think, 4 people we all actually agree, which is really quite wonderful. And let me turn it back. I'm not sure if I turn it to Rob or to Ryan, but I believe we have a lunch break now. Again, panelists, thank you so much for taking the time out. I know you're all very busy people.
Thank you.
We'll break
Thanks for
now
having
for
me.
lunch until 12:30 when we resume for the asset management panel.
All right, folks, welcome back. Welcome back to our roundtable conversation about the future of ESG disclosure here in the United States and indeed around the world. I hope you've enjoyed today's conversations as much as I have, and I'd ask the panelists who will be joining me for the next bit of our conversation to please turn on your cameras and join us. I'm delighted to be leading, or rather I should say moderating, this conversation among the asset managers in the room who will be helping think through what investors want and need from John Coates and his friends at the SEC. And I'm very grateful indeed to be joined by 5 of the leading thinkers on this subject across the asset management industry and the market more generally. Please join me in welcome Adrian Monley of Vanguard, Carolina San Martin of Wellington, Ben Colton of State Street, John Bailey at Neuberger Berman, and of course, Dorothy Donahue of the Investment Company Institute. Welcome to all 5 of you, and thank you again for joining us for the conversation. The subject of this panel is asset managers. What should the SEC do? What should the SEC not do? And I thought we could kick off today, Caroline, and begin with you. Give me a sense of, from where you sit, your perspective on the answers to those questions.
Sure. Thank you, Rob. And it's great to be on the panel today and have this discussion. I'd say our direct answer to your question is that we believe the SEC should establish mandated, standardized disclosure of material ESG issues. And for us as active managers, the case for doing this really starts with our fiduciary duty to our clients. In order to make informed decisions on their behalf and deliver on our firm's mission to drive excellence for our clients and meet their return expectations, we need comparable, reliable data from issuers on those ES and G issues that can impact long-term value. Like many investors, given our focus on materiality, we've looked to frameworks like SASB and TCFD as emerging market standards. But because these frameworks have been voluntary rather than mandated, the adoption has been mixed and inconsistent. And that means that while we recognize the importance of considering these issues, we still lack the information that we need to do this consistently and properly to meet our clients' objectives. So we think that well-designed, mandated standards focused on materiality would provide investors not just more information for its own sake, but really better information on material issues that are relevant to our investment decision-making process for our clients.
So, Caroline, just to follow up quickly, I promised in our prep call for this conversation that I do the law professor thing and ask hard questions. So what I hear you saying is that from your point of view, mandatory rules on the subject requiring disclosure across the market would be desirable. And I want to pull something out there. Can you share me a little bit about what you think of the existing ESG metrics we have in the marketplace and how a mandatory rule might affect their development?
So is the question about kind of assessing current disclosures?
Yeah,
or
assessing the current quality of the metrics and the quality of ESG data that you're using today.
Oh, sure. Well, I think this gets to another key benefit, which is just in coming back to this cost benefit analysis that was spoken about in the session with John Coates. The quality is because disclosures are inconsistent, the standards are fragmented. There's this very complex system today of disclosure on ESG topics, and for all of us, this is both for issuers and investors alike. So we understand the incredible burden this puts on companies. We are spending a lot of time trying to interpret and translate data to make it useful for our investment decisions. So while mandatory disclosure may seem onerous, if it's done with a focus on what's material and keeping in mind what we're really trying to achieve as investors and what's practical for companies, we think it can really address some of this inconsistency that we're seeing in the data and benefit everybody while meeting the ultimate objective.
Makes sense. And I think it's an important point, as John was mentioning in my chat with him this morning. I think he's sort of a keen observer of the cost and benefits of these choices. And what I hear you saying, and this is not the first time I've heard it from the market, one benefit would be to help improve the quality of the ESG measures we have out there now, which I think are a bit noisy. And certainly that's got to do with the information they're built on, which is not comparable or consistent for the reason you've given. Adrian Monley, it sounds like Carolina is pretty far down the road on being in favor of John sitting down and writing some mandatory disclosure rules. Tell us a little bit about Vanguard's perspective on that subject.
Yeah, thanks, Rob. And look, I think as a fellow long-term investor, arguably Carolina maybe a bit more long-term, the index funds managed by Vanguard are of course sort of both structurally and philosophically long-term. So the index funds track companies that are listed in indices. That means we're likely to be sort of perpetual owners of stock. When we think about decision useful information, it's probably largely around stewardship decisions and less about sort of traditional investment decisions. But nonetheless, we still think that consistent, comparable, decision useful ESG disclosures will be appreciated by and important for long-term investors, including index funds. When I think about this, I sort of think about a little bit of history here, Rob. Firms like Vanguard and including Vanguard have been advocating for frameworks like SASB's framework, TCFD's framework for a number of years. And I think we're encouraged to see some adoption by issuers, but frankly, it's not consistent. And at this point in the market, one common refrain I hear from issuers is, well, we're waiting for more clarity on where the regulatory winds are blowing. No pun intended, because it's a very windy here day where I live. But I think that clarity, whether it's through the channel of guidance or whether it's through a mandatory structure, is going to be really important. I would also urge that the voice of investors will be really key, because we all will use the information likely in some consistent ways, perhaps in different ways. I agree with the point around materiality. I know there's been a lot of discussion of this today. At the end of the day, this is not about necessarily trying to shape societal or environmental change, but rather to inform long-term understanding of complex risks and perhaps even better identify opportunities where they exist for the purpose of creating value for the investors in the Vanguard funds. And that is why my team exists in the investment stewardship space. So I agree with the spirit of creating new norms that are easy for companies to interpret and align to, and easy for investors to, again, interpret, digest, and make their decisions through.
That makes lots of sense. And Adrian, I want to follow up on a subject that John and I did touch on this morning, which is the development of international standards and an international standard setter. The IFRS Foundation has suggested that it will stand up a sustainability standards board later this year. And my understanding is that what they'd really like is for the US to join it. Say a little bit about what you think is the likely path forward there, and what might be the preferable path forward from Vanguard's perspective as an investor.
Well, I think what we're looking for, regardless of the path, are pragmatic outcomes that help to get the results we're talking about here: better, consistent standards and better, consistent output from companies on disclosure. I don't know that I'm the right person to opine on, John's decisions or who joins what standard setting groups, but progress is needed. And if that's a step that helps to support progress, then we'd be delighted to observe it.
That makes sense. And as I noted with John, I'll just point out that even on financial reporting measures, the United States has not simply joined international bodies, but instead maintains US standards, but seeks harmonization. Because what I've heard from each one of you on our prep call today, and this morning from our colleagues, is that standardization is really what's needed here.
Yeah, but I think, Rob, importantly, as we talked about before today, standardization is an aspiration. There may be different gradations of it, but what we want as investors, and what I know my team would benefit from, is at least fairly consistent output from companies around the world. So we have the ability to compare peers, assess progress, assess who are leaders, who are laggards, and for our purposes, that helps us to understand how boards are overseeing risks, how risks are being managed, whether they're being managed well or not, and then what the progress is over time. So that's really the purpose for that aspiration. Whether I think we'll really get there in its true form or not, I can't say. None of us on this call are completely in control of that outcome, but I think it's the right aspiration to pursue.
That makes perfect sense. It's an important point, Adrian. Thank you. Dorothy Donahue, I think I'll turn to you now. I'm always interested to hear the perspective of the Expert Investment Company Institute. It was my very great pleasure to be able to work with you when I was on the commission. And I'm curious, where is ICI on this ongoing and important debate about what investors need in terms of standardized ESG and in particular climate disclosure?
Thank you, Rob, and thanks for having me today. It's great to see you again. And, you know, I'd say for the ICI, this has been an issue that we have given great attention to over the past couple of years. We've worked very, very closely with our members and had regular dialogue with them. And what we keep hearing is there really are, so there's one overarching principle, which I feel like I'm echoing my fellow panelists, that there is this need for consistent, comparable financially material disclosure from companies, including with respect to climate risk. But the real question is, how do you get there? And how do you get there in the most cost efficient and effective way? And so where we landed, our board of governors in December issued a statement encouraging public companies to report consistent with SASB and TCFD. I mean, those are organizations that have been looking at these issues for a very long time, and they are very far along. And while we're happy that the SEC is engaging on this right now, they are getting to these issues a little bit later than a lot of the other participants in the discussion. And so, you know, that's where we are, that we would be encouraging public companies to report consistent with SASB and TCFD.
On not necessarily a voluntary basis, you would encourage them to do that. But it doesn't sound like, Dorothy, that ICI is ready to leap on the hustings and insist on a mandatory climate disclosure rule.
Yeah, no, that is right. That is correct. I mean, I think that there are elements of rulemaking that are not necessarily a very good fit for a dynamic topic like climate change. And so some of the cons of doing that were mentioned earlier today. Is it going to result in boilerplate?
Yep.
Is it going to become outdated? It's difficult to change once it's on the books. And so all of that are things that we've discussed and have some concern about.
That makes lots of sense. So, Dorothy, let me ask you a follow-on. To me, it's indisputable what you've said, that this is going to require a dynamic approach, an approach that can adjust to the market, an approach that works with those who provide assurance to make sure that the standards are implementable and doable. That seems like a task for a standard setter, and one to which a standard setter might be well suited. Does ICI have a view about that, about the path forward on getting to a standard setter and whether it should be an international or a different kind of entity?
Yeah, so, you know, I can answer it to some degree. I mean, we are working hard on our comment letter, and we're really glad to hear John Coates say, get those comments in, certainly on time, but early if you can. And so I can't speak definitively, but I can tell you that what we're thinking about is, you know, again, that we really do support the role of a standard setter. And I guess there are different ways that you could get there again. Sort of, should it be the FASB model? Maybe, right? That has worked pretty well. So that would be one way to do it. Our members very, very much want a consistent global standard. But given where we are in the progression globally on these issues, it's really hard to see how we get there, because there are elements of what countries outside of the US have done that our members don't agree with and would not want to import to the US.
Yep.
So again, a lot of the discussion that we had earlier, talking about some sort of a baseline, something like that, I think, you know, really would be something that it would be important and constructive to move towards. And so there's some combination, I think, ahead of us. And so I'm not quite sure what that's going to look like at this point.
That makes sense, Dorothy, but I just want to be specific, because you've made a keenly important point that I want the market participants on the line to hear, which is that if we were to join the International Standard Setter, one of the real challenges would be that they've gone to a place where it would be hard to make work in the US. Double materiality. Dorothy, I was joking with John earlier that when he taught me corporate law, I missed that part. Is that what you mean in terms of where other jurisdictions might be that would be hard to make work in the United States for your members?
Yes, that's exactly right.
Yeah. Well, good. And I want to ask something else, Dorothy, about your perspective on liability for these disclosures. But I'm going to come back to you because first I want to ask Ben Colton to tell us a little bit about what you see in the marketplace. Ben, always insightful, and I'm particularly interested in hearing a little bit about your view of the TCFD and SASB standards. I know you all are familiar with those. Say a little bit about what you see as the path forward here.
Yeah, thank you very much for giving me the opportunity to express my views. I mean, investors need quality, comparable, and material information. Long-term investors like State Street Global Advisors that are quasi-permanent capital need this information. If you think about, intangible assets is increasingly becoming, a substantial driver of companies' valuations. Human capital is amongst the most valuable asset that a company now has. Investors need information on this, and you think about, this was completely different when standards came in from financial accounting standards in the 70s. Tangible assets, property, plant, and equipment were the most prominent drivers of value of companies. But that has completely changed. So, as long-term investors, we only need this information to evaluate things like human capital management, but also from a risk perspective. When you think about the risks associated with climate change, these are systemic risks, and these are common risks across all companies. So, but I don't think that disclosure for disclosure's sake is, and that's not what anybody wants. Your companies don't want that. Investors don't want that. So I think one of the but there has been a lot of work that's gone into TCFD. SASB, investors, including State Street Global Advisors, have explicitly supported this, building ESG products off of this, using this to evaluate companies. So I would say, SEC should look towards these frameworks to consider, what should we be looking at? It doesn't need, I don't think it should be the industry specificity. I think that can be left to SASB or investors to weigh in on what exact metrics they're looking at in different industries. But I think looking at the common denominator, what is important and what impacts all companies, and what information do investors need across the board? Think about climate change. You think about human capital management, diversity. These are impacting companies across the board, and investors want information on this. So I would say, national disclosure regime. I said, you mentioned earlier. I think that that's a really preferable route. Obviously, there needs to be some kind of harmonization or look towards harmonizing with other national frameworks, and also SASB and TCFD. But I think that there's an opportunity to think about what is baseline disclosure. Because if you think about, even with TCFD and something as simple as carbon emissions, the quality of the data it varies widely when you're looking from data provider to data provider, even on something as simple as an objective as carbon emissions. So I think there's a real opportunity for regulators to weigh in, especially on, as I said, these issues that are kind of common across the board.
Now, Ben, two quick follow-ups. First, you might have heard John Coates this morning point out that we've now seen some early human capital management disclosures. And he sounds like he has some concerns about the quality of those disclosures. You mentioned that as something across the market that we should be looking for. Any early reactions to what you're seeing from companies on human capital management disclosure?
Yeah, we're laser focused on human capital management. We're intensely engaging with targeted companies, the largest employers in the U.S. and the UK, to really dive deep into what best practices looks like. And I think it's also the investors' job to create expectations. This is what good disclosure looks like. So and I think it should be both qualitative and quantitative. You need to understand the strategy, but there are also objective metrics. When you think about EEO1 data, there are challenges. We completely recognize that there are challenges, but it is a starting point for us to start evaluating, important information about workforce demographics. So I think this is going to be an evolution. We need to be practical. We need to be pragmatic, but we need to establish, what is baseline disclosure, useful disclosure. When we're thinking about human capital management, things we're looking at are employee voice, for example. What is the strategy? What is the board oversight? of human capital management matrix. So it's something that, and also diversity and inclusion, racial and ethnic diversity specifically, we've called on companies to enhance their disclosure, but it does vary widely from company to company. So I think there's a real opportunity that I think both companies and investors alike would be supportive of.
Ben, that makes sense. And here's my second follow-up. Before I ask it, I want to encourage folks who are listening in to share questions with us through the chat function. I'm delighted to share with our panelists what's on your mind. But Ben, let me ask you this. It seems to me that there's going to be an adjustment process here where we're going to get some disclosure mandates, it sounded like this morning, and then we're going to see how investors make use of that. And how usable it is, how decision relevant it is, and going to have to make updates from that point forward. Do you have any suggestions for the SEC as they think about making their first step and then giving the market the opportunity to respond and give some feedback to what's been done?
Yeah, it's certainly going to be an evolution, and as I mentioned, I think it's first establishing baseline disclosure, something that's common across the board, something that is there is simplicity as well, because I think one of the challenges has when there's not clear expectations that are created from both investors and regulators alike, then there's the opportunity for complexities to start creeping in, and once that Pandora's box is open and complexity is kind of taking over. It just reinforces the bad data or the inability for investors to really look apples to apples across the board. So when you think about things like climate related disclosure, or say on climate, for example, if there's not clear expectations on what a good transition plan looks like, I'm not saying that this is for the SEC to consider, but for investors to consider. We need to outline what does good look like in terms of quality transition plan or human capital management disclosures. Because once the expectations are set, it limits the ability for complexity to start creeping in, because investors need to take control, and regulators also need to look at establishing the expectations. So then you can have an actual accountability mechanism put in place and compare companies from apples to apples and determine who's laggards.
Right. And Ben, I would say that in terms of accountability mechanisms, institutional investors like you have played an important role in making clear what expectations are. So one of the interesting things that's going to happen in the market over the coming year is, to the degree that something is mandated, what'll be even more interesting than what's mandated and how it's mandated is what investor expectations will be about the contents of the mandated disclosure. That's something we can't know yet, but I'm sure, Ben, you'll be thinking about that down the road. Jonathan Bailey, I want to turn to you at Neuberger Berman. I don't think there's a market participant with a deeper, longer heritage on these topics than your firm. I'd like to start with a sort of broad question for you, which is, there are those who might argue, we've heard a little bit of this today, there's some folks listening in who might take the view that this project is not within the SEC scope, and that it draws on a series of questions and expertise that the commission might not have. I served on the commission for a little while, didn't meet a ton of climate scientists. So you might tell me, Jonathan, a little bit about the firm's perspective. Is this in fact within scope? And how do you think about that at Neuberger Berman?
Well, Rob, I think you're absolutely right. There may not be stacks of climate scientists hiding in the halls in DC, but there doesn't need to be, right? There are a series of frameworks, and my colleagues on the panel have talked about them, others have today, that exist, that already have been tested, have already been through comment processes, have had feedback from market participants, and are being used by companies of all shapes and sizes. And so what is the role of the SEC? If you go back to its founding in 85 years ago, whatever it was, protecting investors, facilitating capital formation, and maintaining orderly and efficient markets. And right now, capital is being allocated inefficiently. We are not protecting end investors. And ultimately, that has an impact on the ability of innovative companies to grow and be successful. Let me just give you one example. We have what we think of as being a pretty differentiated approach to proxy voting. We publish well in advance our intentions as to how we're going to vote on key votes. One of the ones we published, which is up on nb.com/nbvotes, is around Berkshire Hathaway. And if you listen to what has been said by the company in relation to a proposal which is about climate, they reference back to some statements from 2015 where they just dismiss this as being material. That may be true, right? But ultimately, what we'd like to see is a framework that doesn't have to rely on shareholder proposals and debate and engagement for these sort of basic disclosures to happen. And that means that if these are material in the view of investors, and the TCFD framework and the votes that you see on these sort of proposals indicate that many investors do believe that they are material, then it is the SEC's role to step in and ensure the information is available. And that's why we would be supportive of a disclosure regime. Now, critically, the range of different things that could be captured in such a regime is very broad. And so we don't think that you need to go all the way through to European Union taxonomy and SFDR type of levels of principal adverse sustainability indicators, right? There's no need for the SEC to be going into that broader scope. Instead, embrace the building blocks mindset that we've seen emerge over the last year or two. Start with the things that are broadly accepted, SASB and TCFD, and leave those optional add-ons where perhaps there's not yet the same consensus, and we haven't seen them tested as much by issuers, and not all investors need them. Leave that as optional, but start with the building blocks mindset. Start with TCFD and SASB, and ultimately we think that's in our clients' interests.
Now, I want to ask a question, Jonathan, of you, because it's just come in from our audience, and I think it's spot on to what you've just been saying. Are you at a place where you feel you are required to, or do, or should integrate ESG and in particular climate into your investment process now? Are you doing that right now? Are you going to wait until consistent reporting standards emerge? Where are you at Neuberger in that process?
No, I mean, of course, we're very public. We publish every year what proportion of our client assets are managed with ESG integration that's demonstrable. And at the end of last year, 80% of the 430 billion or so that we manage on behalf of clients met that high bar. And that's up from 25% about 5 or 6 years ago. So we're not waiting for this disclosure to happen for us to try and estimate this data and to use it to the best of our abilities. But this is why the market's inefficient, right? My friends who are primarily passive managers, they rely on us as active managers to identify value, right? To set price in the market by buying and selling. And at the moment, we buy and sell based on flawed disclosure and limited data. And so that has an effect for all clients and for all investors because price discovery is constrained. And so, we need enhanced data so we can move on beyond Scope 1 carbon emissions to the things that we think are going to be more cutting edge in alpha generation for us as active managers. So no, we're not waiting. And I think critically, nor are many companies, right? Many companies are not waiting until the regulators have endorsed this, but we know there are laggards. And given the pressing challenge of issues like diversity and climate, we shouldn't be sort of moving slowly here. We should be providing the baseline of security to those issuers to get on with providing this disclosure.
Interesting. All right, Jonathan. Now, I'd be remiss not to share another question that's come in from our audience, which is the degree to which the SEC is also looking at funds and the degree to which they are actually integrating ESG in their investment and voting decisions. Jonathan, you might have noticed among the many ESG initiatives that Acting Chair Allison Lee moved forward was a risk alert from my friends at the Office Compliance of Inspections and Examinations, noting that they will be focused on what integration is actually happening behind the scenes at funds that have been marketed in their prospectus to investors on an ESG thesis. Now, Jonathan, what was the firm's reaction? Now, my guess is you all having been well ahead on integration, you might welcome that development. But I'd like to know more about how the market has begun to internalize the SEC's focus on making sure that funds that raise money on an ESG thesis mean what they say.
Well, look, I think it's only appropriate that that if you're going to hold yourself out to be doing something, that there is scrutiny of that, both by clients, the advisors that exist out there, and by regulators. So, of course, that's something that's entirely appropriate. And look, we've seen the flows into funds that use the word sustainable or impact or ESG, and we also look at the holdings of some of those funds. And of course, it's easy to read the newspapers and sometimes be confused as to what's going on. So transparency in the investment process and transparency on how that leads to the holdings that are in place is obviously something that's important. And what I think is going to clearly happen over time is that there will be more consistency and coherence about the use of these types of names, right? The names rule is obviously part of that. And I applaud the work of the ICI and others who've tried to sort of bring more consistency, in that. What we would prefer not to have happen is the sort of very formulaic approach that we've seen happen in France and in Germany, which is really doesn't allow for the sort of flexibility and innovation in product that we know is what our clients, like to see as the ESG issues that they want to see expressed in a fund continue to evolve.
It's well said, Jonathan. And let me, Dorothy, I'm going to come right back to you because ICI has really been a leader at the cutting edge in helping create some standardization, or rather encourage their members in that direction, while perhaps not being quite so prescriptive as some European jurisdictions have been with respect to ESG integration. Can you say a little bit about that work?
Yeah, sure. So, our members came to us in early 2020 and really wanted us to put forward a terminology that could distinguish between the types of ESG strategies that funds were offering and try to get a consensus among our members as to how they would describe their products. And that way investors would be better able to choose among different funds and compare them. So we spent months going over, talking to folks, and came up with, ESG integration we look at as being at one end of the spectrum, because that really is what many funds do that are not so-called ESG funds. That our members look at this as being another financially material ingredient to putting together a fund. So I think that's an important distinction to make. And then moving along the spectrum, there are inclusionary funds, exclusionary funds, and then impact funds at the end, which, the impact funds are looking at going beyond seeking financial return, but also some positive impact. So we've had very good pickup on the terminology. The feedback we've gotten from our members is that they really have incorporated it. In terms of the risk alert, I think generally our members favor when the SEC issues risk alerts. It's certainly better to hear what's on the SEC's mind before they come knocking on your door and say that you're not doing it right. So I think having that information and being able to take that back and adjust your operations if need be, or, again, just kick the tires, is something that the industry really appreciates.
That makes good sense, Dorothy. And what's more, I would think that ICI being ahead of it almost by a year in that way, gave folks something to hold on to as a response to OC questions. Yes, we have thought about this. Here's what it looks like. And I'm wondering, maybe you'd rather keep it confidential, but my guess is that the ICI has been able to engage with OC and others at the commission, letting them know that these standards are available and maybe a helpful starting point for their questions.
Yes, absolutely. No, as soon as we published it, we reached out to the SEC. And as you know, the SEC really, is, always willing to listen. And so we did share it with them and had conversations and spoke to all the commissioners and the investment management and the OC staff so that, it would be broadly understood that members were on board with this and this is the industry's thinking.
Makes sense. Caroline, I'd like to come back to you with a question that we haven't addressed, but I promised we would come back to, and now I'd like to dig in a little further. What do we do about the prospect of securities law liability around disclosures of this kind? And you heard John Coates this morning reminding folks that at the moment, if companies post a disclosure on their website in response to a request for climate information, they are responsible for what's been published and posted. Would you encourage John and others at the SEC who are listening in to consider a safe harbor or some kind of limitation on liability, Carolina? Or do you think if the rule comes out this year, it's a securities law actionable disclosure from day one?
Sure. Well, first, I'd say that I really appreciated his comments this morning, just reminding us about the baseline, and that information, when it is provided to the market, is still required to meet a certain standard of accuracy and reliability. So I think that's important to keep in mind. But I also recognize that as the disclosure regime evolves and is established, I'd say we should take a practical view here and really help the industry develop the infrastructure it needs to do it well and to get to the right result. And I also found, to this point, compelling that what you raised, that there's a risk of leading, the liability fear leading to boilerplate disclosure. So I think we need to really balance the need to drive accurate information. And remember, that's the goal we're all striving towards, with some protections in the near term to really help everybody, bring everybody along, investors, the insurance community, as well as corporates, so that, in 5-10 years, we're going to really be in the right place and keep that long-term objective in mind.
That makes good sense. Adrienne, what's Vanguard's perspective?
I think in a prior conversation, Rob, you, Carolina, and I were talking about the difference between backward-looking information and forward-looking, right? Which, when we talk about issues like climate risk, that's an important distinction. We would expect anything that the companies make public to be as accurate as possible, but I completely agree the risk of boilerplate disclosure here renders all the progress we're talking about irrelevant. And so I think no investor is interested in that. On the forward-looking side, companies are now being asked to set targets, anticipate future transition plans, anticipate results and outcomes. And the likelihood of any single one of those estimations of being accurate is probably zero. But investors are trying to understand how well a process that's underway today is likely to proceed. And so again, I would just encourage practicality and consideration for the risks that companies are surely, if not already articulating in this process, will articulate through their own comment letters. And I'm sensitive to that. I think Vanguard is sensitive to it.
That makes a lot of sense. Dorothy, let me ask you, where's ICI on that? Or to the degree you're still formulating a view, would love to hear the thinking about the prospect of issuers facing a non-trivial risk of securities law liability in light of these new disclosure requirements.
Thanks. Yes. And we have been talking about it, and where members are now is that there should be some sort of protection. And we've talked about different ways that the SEC might go about that. There might be something like a safe harbor for some period of time, or a temporary no enforcement position that the SEC could take, and really fostering the dialogue and the learning that can go on by investors and companies and other experts in the field coming together and trying to figure all of this out, and having that protection from being, in a gotcha situation where, there's been a foot fault, but, that again, in good faith, the company has tried to put forward information that they have the best information to put forward at the time.
Makes sense. Let me follow up and ask challenge a little bit that conclusion. Although, as you know, I'm quite open to this prospect. One of our colleagues and friends wonders, in the audience wonders, isn't the way to do that to make sure CorpFin has a really robust filing review? Wouldn't the best way to do this, rather than necessarily provide a blanket safe harbor, or if you're going to do a safe harbor, make it very temporary, and make sure CorpFin is a very active reviewer next spring of the filings that come in under these new standards? Is that another way to go about it, Dorothy?
Well, only if they hire a lot of climate scientists that have a crystal ball that can look into the future. I mean, that's what we're dealing with here. Nobody knows. And so we're all making our best guesses. So yeah, I would not put that burden on the CorpFin staff.
Interesting. Okay. Well, we could both agree that if you're going to, you would need quite a substantial change in the Human Resources Department at the SEC. Ben, I want to turn to you and ask you a question about audit and assurance of all this. So let's assume, as John suggested, we're going to move forward with a disclosure rule sometime this year. It's going to be a disclosure mandate across the market. We're going to get more detail on exactly how to implement it from accounting standard setters. But Ben, there's going to be an assurance process around that, an accounting and assurance procedure on which companies get comfortable that the numbers they're publishing are rooted in reality. Is the audit and assurance market ready for that? If we had to start from standing tomorrow, would the Big Four and others be ready to provide assurance of those numbers, or do we need to give them some time to scale up that business?
Yeah, no, I think it's a good question, and I think that this is an evolution for investors, for companies, for quality assurers. There needs to be expertise. We were talking in discussions earlier in the prep call. Having, whether it's the climate scientist on the assurance side or in the SEC there needs to be a scaling up of training. There needs to be it's going to be an evolution in terms of ensuring that the quality of the data and the disclosures are up to par. And I think that we need to be mindful of this and take some time. But I think having a starting point of what good looks like and having expectations of what good looks like is the first step.
Interesting. Jonathan, what say you?
I think the auditors are all reasonably well equipped. They are not the people I worry about, given the amount of services that they see to pitch us. And just a shout out to those that worked on our sustainability linked credit facility, who are helping us to tie our own borrowing costs to disclosure on diversity and progress on other ESG metrics. So we found them to be very adept at that. I think the challenge for companies is going to be more around getting themselves out of sort of management indicators and more into just sort of the process that you have to deal with a CFO and the IR department and goodness, even the lawyers. That I think is more of the challenges, the internal politics of doing these shifts. But again, we've seen plenty of companies, small companies that are coming to the public markets for the first time, capable of doing it, as well as the very largest. So I'm not worried about that. What I am worried about is the dynamic materiality stuff, right? I'm worried about a one-time set of rulemaking and the training of legions of people to implement it. And then we move forward 3 or 4 or 5 years, and the issues that are material are shifting. The data that we need is shifting, and we haven't created a standard setting organization, a body that can actually keep up with that change. And I think it's only if the SEC explores the value of a standard setting body that can continue to maintain that evolution, that will be able to have the sort of continuous investment in ensuring that investors have the right type of data and disclosure for the needs that we have in 5 years, just as much as the needs that we have today.
Jonathan, I'm merely the moderator, but to offer my own editorial 2 cents, I couldn't agree more with that last point. And our very next panel, starting in just 17 minutes, will be my co-director, Ed Rock, digging into what such an entity should look like, how it should be governed, and joined by some of the leading experts in the interaction of law and accounting questions to discuss just that topic. Jonathan, my own view is that discussion has not reached the attention of as many people in the market as it should, because where the rubber will meet the road is going to be decided in part by those standard setters, and more importantly, whether the dynamic changes necessary to keep the standards useful to investors are going to depend on that standard setter. So I was glad to hear Dorothy mention that earlier, and I'm glad to hear you mention it too. I want to turn to a subject we haven't said anything about, but we should. And Carolina, maybe I'll start with you about the information that you currently get from issuers about questions of diversity and inclusion. Hard to think of a more pressing matter for the nation or for its companies. And not obvious to me that all the decision useful information that you might be looking for is finding its way into corporate disclosure. Say a little bit about how you're grappling with that.
Sure. This is a subject that we've been spending a lot of time on in the last year, and really building on the work on gender diversity. And we always thought about it in a broader sense, but we've really zeroed in on racial and ethnic diversity this year. And it's been amazing to see how challenging it is to assess that. With gender, it's an easier metric. It's more, people are more used to disclosing it, but everything else is just missing. So we have really grappled with the data and come up with an approach to focus on disclosure first, because that's where we see the biggest gap, so that we can really assess and work with companies to drive improvement where we see opportunities for that. So I'd really include diversity and inclusion as a key area of focus across companies, similar to what we've seen on the climate side. But I do want to just quickly use the mic to make one point that I would encourage SEC to really think broadly about material ESG disclosures, thinking about issues like diversity that affect cross sectors, but also industry specific disclosures. I think they both need to be tackled together. Probably a standard setting organization is best place to do that. But I think it would be a missed opportunity to not really think broadly about all of the material issues. And it's at the industry level that really we get the most meaningful data.
We've gotten another question from the audience that I just think this is from the Wall Street Journal's terrific Dave Michaels. And if you don't read Dave, you should. Adrian, I'm going to direct his question to you because he's asking, as usual, the right question. Dave asks, in addition to narrative disclosures, do we really need a quantifiable measure? Is that a must-have for investors to make use of these new disclosures? Or would narrative disclosure, in your view, suffice? What do you think, Adrian?
I would say a healthy combination. I mean, depending on the topic, right? Some topics are really difficult to quantify. I am empathetic that some companies, it may take years for them to integrate and combine systems, particularly companies that are large, integrated, complex organizations. But ultimately, for the comparability, quantitative metrics are going to be important. I do want to make a real plug, though, for qualitative metrics and qualitative disclosures. You know, things like describing in more detail the board's oversight, describing where risk management really lives, how it's evolved and integrated, describing how ES&G matters get integrated into strategy, you know, particularly, as Carolina noted, diversity, equity, and inclusion matters, where oversight for that sits. We're not going to be able to uncover that through just quantitative metrics, right? We need companies to give us more discussion, more analysis, and more description of what they're doing. It frankly gives us the opportunity to give companies feedback, which I think is a really important part of the process. We've not talked a lot about that today, but disclosure isn't really just a one-way thing, right? We consume it, we give companies feedback about our reactions, how we compare them to others. That gives companies tools and to decide their long-term progress and direction. Many investors do this, and so I would want companies to be able to have the opportunity to deliver both.
That makes sense, Adrian. And we have lots of examples in the SEC's history combining principles-based qualitative disclosure with quantitative measures. A good example is executive compensation.
Yes.
The SEC invites people to literally philosophize about executive pay in securities filings, which they do, but also requires you to disclose how much you paid. And that's a combined approach with a lot of heritage at the SEC, and it sounds like one that Vanguard might think useful in this context. Carolina, do you agree with that?
Rob, if I may just chime in quickly, I think it applies to so many ESG risks. And so, you know, I think that the executive pay example is a really good one. We could apply it to how companies disclose their DE&I strategy, their climate strategy. I saw a question here about corporate political activity. I think it all applies, but both quantitative and qualitative measures and disclosures matter. They do give investors the tools to both sort of understand process and then check for results.
Makes sense. Carolina?
Couldn't agree more. I think it really is about having both pieces together. What we're lacking now is the consistency on the quantitative and metrics, some as well on qualitative, but we have more of the qualitative. That context will remain important, but the combination will really be the powerful tool that we need.
That makes very good sense. And Adrian, since you mentioned it, and being an SEC alum, I feel the need to disclose my own involvement in the corporate political spending area. I'm the author of a petition urging disclosure of that subject at the SEC. John mentioned it a little bit earlier, and I'd be remiss, Adrian, not to point out a recent change in Vanguard's policy with respect to that subject. Your new voting guidelines are out, and I commend them to everyone in the marketplace. Let me ask, and Jonathan, maybe I'll turn to you for this one, a question from another colleague I've worked with closely, whom I just have enormous respect. The tremendous Peter Rasmussen of Bloomberg Law asks us, Regulation SK currently requires issuers to disclose the extent of the board's role in companies' risk oversight. Is that enough for institutional investors during a period like this one? Or should the SEC expand upon this and require more broader disclosure of exactly what the board is doing to oversee risks in this area? What do you think, Jonathan? Is that somewhere the SEC should be spending some time?
My instinct would be that may not be the area that the SEC can add most value. I think we find in our dialogue with companies that when we press them around who exactly has oversight of different material risks, whether it sits with a committee or with the chair or has the full board, I think we tend to find that that's a healthy dialogue. I can think of an engagement that we were doing only a couple of weeks ago with a large US industrial company around where climate risk specifically was overseen, and there was sort of some generic qualitative language that was available, but we didn't think was precise enough. But through dialogue, we were able to ascertain sort of sufficient confidence that we felt comfortable with the oversight that was there, and ultimately decided not to cast a vote against individuals for lack of oversight, which we might have done had we relied solely on the disclosures. So I think at this point, I think we're finding that through discussion with issuers that's something that we can get good comfort on. I think the broader point about sort of qualitative versus quantitative, I would just sort of keep in mind that sometimes, the qualitative can be an opportunity for filler and to not sort of actually provide the numbers. And there are things where we really do need sort of basic quantitative data. And, some of the issues we discussed so far around EEO1, around Scope 1 and 2 emissions and so on, right? Those are sort of minimum requirements. So qualitative is great, but let's make sure we don't kind of create a way out without those minimum data points.
Oh, Jonathan, being an academic who loves him some data, I am delighted to agree, of course. But let me push that just a little bit further, because I believe in quantitative measurement, and I think it'll be crucial to anything that John and his friends do this year. But let's be fair, there is a cast of third-party sellers of rating scores that have been involved in this area. We haven't talked about that at all. And my NYU colleague, Sam Liss, asked about it. Let's talk a little bit about it. Are you relying in a large part on the MSCI Sustainalytics or the ISS ESG product to drive your internal filters? How do you feel about the market race to become embedded in those discussions? And what are the challenges you're facing, especially as sooner or later you yourselves will be rated on your ESG efficacy? So tell us a little bit about the competition to be the rater of choice in the market we have now.
So we do actually rate ourselves using our proprietary framework. And I hesitate to say that we do not get 100%. So there's still some progress that we would acknowledge that we need to make. But look, I mean, we're a shareholder in MSCI, and we've enjoyed their pricing power and their market influence that they've managed to build as a shareholder. But as a customer, I see the other side of it sometimes. And they have been very successful in developing that business. And if I look at the way that regulators in some markets are going, particularly Germany, there seems to be a consensus that they are effectively going to be a gatekeeper to sustainable products, right? And that's not necessarily how we look at it, right? We look at it as saying that you need to bring a range of different data points and qualitative judgments together when you're assessing the strengths or weakness of a company, and that none of these third-party data providers and their scoring, is sufficient for that. So it's important that we continue as active managers who are doing that work to rely on our proprietary ESG quotients, as we call them, and the judgment that our analysts have, in part because the methodologies and the peer sets that we're using can be much more customized, right? We're choosing often between a pretty small set of potential investments. We're not trying to compare one company against 10,000 other companies around the world, right? We're building concentrated portfolios. So we need an assessment process that allows us to look at value within an investment universe that's much narrower and more specific. So that's why we have our own approach. I recognize if you're building an index-driven ETF product or some sort of quant thing, you don't have the luxury of having those analysts. You don't have that judgment. You're going to have to rely on third-party data, and so obviously there's going to be a business there for that. But I do want to make the point that from an issuer perspective, it is often frustrating because we will be engaging with them on the one or two things that we think are really important, where their disclosure could improve, and where it's going to help us make a different investment decision, right? It's going to ultimately change capital formation. But at the same time, they're getting, sort of standard form letters asking them to, improve their GRI aligned reporting in order to get, an extra box check on a Sustainalytics score. And that is often confusing for IR. It's frustrating. It's frankly a waste of shareholders' capital and scarce management resource. And so it's really important that investors continue to reinforce a materiality-driven approach that allows companies to focus on what ultimately is going to shape our investment decisions.
Adrienne, could you share Vanguard's perspective?
Yeah, I mean, I'm just going to bring us back to the beginning here, right? One of the great benefits I'm hoping for progress in the disclosure space is that it will provide better source data for all of these ESG data providers. I hear from companies that the quality of ESG ratings is a real source of frustration, not to mention the process that Jonathan noted. They receive hundreds, if not thousands, I think they feel, of surveys seeking more ESG data. Well, if we have a better agreed upon standard that is consistent, that has a combination of qualitative and quantitative information, then ESG data providers will be able to create better quality output. Because they can't today, Vanguard doesn't rely on ESG ratings for any of our stewardship related decisions. We have to conduct our own manual hands-on work. So I aspire for the market to be smarter on the ESG front, but it's going to start with that high quality source data, and that's going to be the disclosure we're talking about here.
I've always, while I was on the commission, I thought it just a little ironic that folks who would complain frequently about the quality of ESG related data, a complaint, by the way, which I think is empirically correct. The MIT project on the subject, I think, has some very persuasive data on that. But the same people complaining about it were adverse to mandatory disclosure. And it struck me as, I don't know, Adrienne, a little bit ironic. What do you think?
I think we can kill two birds with one stone here.
Yeah, that might be right. So, folks, we have talked a lot about the next steps in the creation of a standard setter, what its governance will be, how it will be formed. Clearly, that was very much on John Coates' mind, and that'll be the subject of our next panel. But before we turn it over to them, I thought we could poll each other about the desirability from your points of view about mandatory climate disclosure at the SEC this year. On a scale of 1 to 5, where 5 is you're absolutely committed to mandatory disclosure this year, and a 1 is you will hunt John Coates down in Cambridge when this is all over to hold him responsible for having the audacity to mandate this transparency. I'll start with you, Jonathan. What say you? From 1 to 5, 5 being the most enthusiastic. Is Neuberger ready for mandatory climate change disclosure?
We go with a 4, and I just it's a 4+ in the sense that don't just keep it to climate. Do think about the issues that go beyond that, and a standard setting body could be helpful in that regard.
I want to note, consistent with my philosophy as a commissioner, you are invited to give both quantitative and qualitative disclosure regarding your, as Jonathan has just done. So Jonathan, a 4+ with the qualitative disclosure you've added. Ben?
Yeah, I would echo that. We would go with the 4. And also echo that, not just climate, also think about human capital management. And I loved John Coates' analogy with qualitative and quantitative, or the principles based with the speed limit and the reckless driving analogy. I think that's spot
on. Terrific. Carolina, where are you?
I'm with Jonathan on a 4+, and my qualitative disclosure would be the importance of remembering flexibility and embedding flexibility in the process. So that's really the plus. It's a recognition this is going to continue to evolve, but we should go with what we have.
Understood. Understood. Dorothy, where's ICI on this?
I would say a 2. And I would say, again, sort of let the organic growth continue to happen and absolutely compel forward in terms of improving the source data, but do so through a more voluntary way.
I see. So just to be clear, Dorothy, is it a 2, but we're still talking about it? Or is that number, to borrow a phrase from my previous career on Wall Street, is that number firm?
Well, I guess you'll just have to read our comment letter when it comes out.
I'm sure the market will look forward to that. Adrian, where's Vanguard?
Yeah, we'll land in the middle here. I think we agree with the spirit that flexibility will be important, as will pragmatism. But we're definitely above the two. We do think that some elements being mandatory across all of these relevant material topics is probably among the pragmatic solutions that the SEC can help to offer.
Makes sense. Well, folks, as you've just heard, there are several $1 trillion of investor money quite prepared for mandatory disclosure, at least on the subject of climate, and maybe, as Jonathan, Ben, and Carolina suggested, even plus. And as you heard from John Coates this morning, that appears to be a subject under consideration right now at the SEC. Now, we've agreed all day today that whatever happens next, there will have to be some standard setter who'll be able to make dynamic adjustments to these standards as circumstances on the ground change. And our next panel will address that subject. But first, please join me in thanking Dorothy, Adrian, Carolina, Ben, and Jonathan for their market-based insights. As always, exceptionally thoughtful. And we look forward to continuing this conversation with you as matters evolve this year. Thank you all. Thanks, folks. And without further ado, I'll now turn it over to my co-director, colleague, and friend, Ed Rock, who's going to be leading what I think, and I have hinted several times today, is really where the rubber meets the road. And that is the creation, governance, and oversight of a standard setter who would provide the standards under which many of these matters will be measured. Without further ado, Professor Rock, I look forward to the panel. Take it away.
Thank you, Rob, and thanks for the great setup. We all heard John Coates this morning pretty clearly signal that what he's interested in is hearing about what a standard setting body would look like, how it would be set up, and some of the core reasons for it, namely the ability to be flexible as we go forward. This session is devoted to drilling down on that set of issues. We have really a wonderful group. We have Janine Guillot, the CEO of SASB, Alan Beller from Cleary Gottlieb, who is a past director of corporate fin from 2002 to 2006, Amy Boris, head of Council for Institutional Investors, who can give us the perspective from her members, and John White from Cravath, who is also a former director of corporate finance from 2006 to 2008. The questions here are varied. One set of questions is what is a standard setting strategy? What are its advantages? What are its disadvantages? We also need to focus heavily on how should a standard setter be set up? How does this fit with the securities laws? And finally, we need to focus on the investor's perspective. What kind of standard setter is going to meet the demands and be acceptable among a wide range of investors? We're going to start with Janine, who runs SASB. Janine, what are the advantages and disadvantages of a standard setting strategy?
Yeah, so I think the way we have to start with thinking about this whole conversation is that ESG data right now is a market infrastructure problem. And it's a significant market infrastructure problem. So investors today are making decisions. They're trying to integrate ESG information into investment making, and they're relying on an entire ecosystem of data and analytics and rating providers. And that ecosystem in many ways is built on a shaky foundation. And we often use the analogy of financial accounting standards where there is a comparable ecosystem. There's a huge ecosystem of data analytics and ratings providers for traditional financial information. And that ecosystem is well understood and is accepted because it has a solid foundation. And that foundation is financial accounting standards. Everyone understands the process, they participate in the process, they accept the outcome. And then those companies report using accounting standards, and so you have high quality information and feeding the ecosystem. That's what's missing today in ESG data. So we have always thought, and SASB was founded on the premise that providing sustainability disclosure standards would put the ESG information ecosystem on a more solid foundation. That's important. I think if we start with the conversation about, okay, this is a market infrastructure problem, you then get to the question about what's the best way to solve the market infrastructure problem. Do you do it through regulation, or do you do it through some sort of market-led standards? I think what's really important is that those two ideas are not mutually exclusive. And in fact, they can reinforce each other. And today, if you look at financial accounting standard setting, the legal and the regulatory environment actually reinforces the role of a private sector standard setter. And that's an important thing. These things are not exclusive. But I would say we think a standard setter is essential, an essential solution to this problem, and for several reasons. And I think John Coates put it brilliantly around this is a dynamic environment, and therefore a standard setter can inherently be more responsible for a dynamic environment. I think, as you heard from the investor panel, that the desire for a comprehensive ESG solution. I think a process that is the SEC just going through rulemaking after rulemaking on a whole series of different topics is going to be inherently.
Your microphone is coming in and out. If you could.
I'm sorry. Am I closer now?
That's better, yeah.
Yeah, so I think a process where the SEC goes through a whole series of rulemaking on topic after topic is going to inherently be slower and less responsive than a market-based standard solution. So I think those are two important things. But I just want to also emphasize practically, and this is based on SASB's own experience setting these standards, there are some real practical benefits to a standard setter. One is that we've heard about the concept of materiality being from the perspective of what is relevant to the reasonable investor. We completely agree with that. But what we know is that investors are not a monolith, and investors have a very wide variety of views about what constitutes material information. A standard setter and a standard setting process, governed by a conceptual framework, helps develop a consensus view or a broad view of what's material information to an investor. Without that, and to think about this from the perspective of companies and cost benefit to companies, every individual company is left to a situation where it needs to try to figure out what that consensus view is among its investors. And it will hear contradictory views. Companies will hear contradictory. The standard setting process is a way to develop a consensus view among investors.
So can you make this concrete? Can you take us through how a SASB standard is actually set?
Yeah, so SASB has two key criteria for a topic to be included in our standards. One is evidence of investor interest. The other is evidence of financial impact. And so the process is, and we have a research team, sector-based team. I think many of you listening know that the standards are industry specific. We have a sector-based research team. It monitors issues in that industry. The research analysts are in touch with both investors and companies in those industries. And that's the feedback loop for how our standards need to evolve. We then do research on those topics. We ultimately make a decision about whether to initiate a standard setting project, and then ultimately issue exposure drafts for public consultation. And to just give you an example, we have 12 active research and standard setting projects right now, ranging from everything on human capital, which is 77 looking at human capital topics and across all 77 industry standards, to very specific industry specific standards, like how do you measure hazardous waste management in mining, or how do you measure systemic risk metrics in asset management. So it's a whole range of topics, but all of those, the processes are mirrored after financial accounting standards. But I want to just add one quick thing on what that standard setting process does is it helps develop an investor consensus. Equally, it helps develop and provide company expertise and insight into the process, because companies are essential when it gets to ensuring high quality comparable metrics. What we've learned through our standard setting process is that investors are very good at identifying the topics they want to understand. They want to understand diversity and inclusion. They want to understand scope 1, 2, or 3 greenhouse gas emissions. They want to understand transition targets. Companies are much better at being able to come in and say, this is a metric, this is a comparable metric. This metric might have unintended consequences. And so having real input from companies into the standards development process. And so we really think if you step back, the best outcome here, if you're talking about decision useful information markets, is a standard setting process leveraging the expertise of both investors and companies. And I'll just close with one quick thing, Ed, and then turn it over. But we do think that what gets really confused sometimes in this conversation is decision useful information for markets and information to achieve public policy objectives. Those things sometimes are the same, sometimes they are not. And a market-based standard setting process, I think, most and best suited to decision-making information for markets. If you want also to achieve information to achieve public policy objectives, that is often a regulatory solution. And so I think really thinking about what's the purpose, what's the target user, what's the use case is also really important. So I'll just stop right there, Ed, but hopefully that provides a little clarity.
Terrific. And a follow-up. So one of the advantages that John pointed to for standard setting is that it can be dynamic. It's easier to update than SEC mandatory disclosure rules. How does SASB handle the updating challenge? What triggers an update for a standard?
Yeah, that's a great question. So think about it as a funnel. We have a couple of different ways we decide to trigger something as an update for a standard. One will be market feedback on the existing standards. We have a standards advisory group. It's got 175 people on it. It's about 2/3 companies, 1/3 investors. And that standards advisory group gives us feedback on the existing standards. We also have set up through our website. We just take comments on our standards all the time, just through our website. All of that information funnels into our sector analysts. So the research team is organized by sectors. The other thing is the entire role of the sector analyst is to monitor developments in the industries they cover. So that will be academic research, that will be, just sell-side research, buy-side research, that will be what's being covered in the popular press. So the sector analyst's role is to monitor research, it's to monitor the feedback, and then it's to make some decisions about proposals for improving the standards. Those then go formally to our standards board, which kicks off either a research or standard setting process. So that's the process we use.
Terrific. Alan, you are director of Corp Fin. You're on the board at SASB. You've been on the board at IFRS. How should a standard setter be set up? What's the design challenge, and what's the architectural approach such that it can command be worthy, if you will, of the SEC saying, you've got to comply with a standard from one of the following standard setters in order to be a public company?
Thank you, Ed. And am I off? Good. Thank you, Ed, and thank you for letting me be part of this. This is a great panel. I think it's actually, I I think if you're trying to figure out how to set up a standard setter, at least today, where there is still a lot of attention being paid to the possibility of a global standard setter, I'd expand your question to how do you set up a standard setter so that it's worthy of the SEC's approval, worthy of the EU and EFRAG's approval, and frankly, worthy of the approval in other major markets around the world, Japan, certainly, China, certainly, and I'm not, and a lot of others, so that I don't insult anybody by leaving them out, by not naming them. And so it's really not just a question of keeping John happy, although that's and the commission happy. It's really a question of doing this on a global basis. My own view, and the holy grail here really is a single global set of standards. That would require a unprecedented level of cooperation and success. I suspect everybody on my screen knows, and most, if not all, of our audience knows, it's where the IASB and the FASB failed to reach full convergence and adoption by one of the other. But thinking about that and having that under the purview of a global standard setter is, I think, the home run here. It is made, I think, slightly more likely by some things that a global standard setter could do together with regulators around the world. We've heard talk of this idea of a building blocks approach. I think it is the only way that a global standard setter could operate, and that would be where the standard setter comes up in effect with a baseline of standards, topics, metrics, qualitative, quantitative, but that other jurisdictions, when they adopt those standards, can add on. We already have in the EU with accounting standards the ability of the EU to opt out as part of its endorsement process. They have done that in the case of derivatives a couple of decades ago now. Whether or not the EU will endorse the new insurance standard is still an open question, I believe. And so those variations which are very controversial in the accounting world. I think in the ESG world, if you're going to have a global set of standards, it's going to have to be accepted that you have these kinds of variants, even though they have largely been a subject of controversy and even resistance in the accounting world. The advantages of a standard setter, and Janine has already covered most of them. I'm not going to repeat what she said, but I'll throw in a couple more. One of which is, I think a standard setter would be a more flexible location for the development of a combination of cross-industry standards and industry-specific standards. The SEC has industry-specific standards. They're called the industry guides. They live in a corner that's much neglected in the Corp Fin offices. They occasionally get amended. A couple of them have been withdrawn recently, but the SEC is not good at doing industry-specific metrics. It's partly a question of resources, but I think it's partly a question of just what they view their mandate as being. SASB is an example, and I don't, I am on the SASB board, but this is not a SASB-specific comment. SASB demonstrates that a standard setter, whatever it is probably more fit for purpose when it comes to developing industry-specific standards. And so I think that's an advantage. The other advantage, which Jalene alluded to, but I think is much more important than people perhaps think, standard setters are not models of nimbleness, but they are models of nimbleness when you compare them to the regulatory structure. We don't have much example of nimbleness in the ESG area because there are no compulsory ESG standards. And so you don't have the pressure to move quickly. Janine absolutely accurately described the way SASB updates, but it doesn't have people banging on its door every 10 minutes. You have to change this because our 10Q is due in 45 days and your rule became unworkable a week ago. The accounting standard setters have lived with that issue for years, decades, and have proven that they can act, they can certainly act slowly if they want to, but the insurance standard is 11 years and still going. But they can act quickly when they need to. If you think about the leasing changes that both the SASB and the FASB and the IASB developed in less than 3 weeks, at the beginning of the pandemic and all the lease modifications, that's an example of the nimbleness that a standard setter can give you if it has to. The accounting standard setters are also, I think, clear evidence that you can have a standard setting process, which the SEC prides itself in a similar process, and I think it should. Wide input, broad consultation, due process, cost-benefit analysis. People can argue about whether they do it right, they do it wrong, how robust it is, but they've certainly shown themselves capable of doing that. The IASB and the FASB have equally shown themselves capable of doing that. And one of the advantages of an ESG standard setter is that that is certainly something that you could do. Having said all that, it's still the case that there are formidable obstacles to global acceptance of a standard setter. And here I'm going to flip perspective because I think, Ed, that's what you would like me to do. Formidable obstacles to US acceptance of a global standard setter. One is the whole issue of governance, independence, funding. That was one of the reasons that IFRS came a cropper in the financial area. I don't think that a global standard setter, including one that's developed under the IFRS auspices, it could be better, but I think the US is still going to have trouble. I think the level of representation that the US would have in a global standard setter is less than the US would politically and regulatorily find acceptable. The FASB board, the IASB is 2 Americans out of 13. The IFRS trustees are 3 Americans out of about 22. I think the rest of the world thinks those numbers are about right. I don't think the United States thinks those numbers are about right, or at least the policymakers in the United States. And so that will be an obstacle. And I think the whole issue of the political issue of embracing something that's not based here, while I don't think it necessarily should be an obstacle, I think it will be a political obstacle. And that leaves you with what I think is next best, which is how can the US be part of a global standard setting ecosystem without adopting a global standards board. I think that involves some kind of a US standard setter. In terms of architecture, I would think that the SEC, and it would be done under the auspices of the SEC, obviously. And they would have to be the moving force that said, this is what we want to do. I think if they do that, they should use the existing resources to the extent available. That obviously includes the SASB, but again, I'm not here to preach the SASB gospel. I think there are other existing resources around the world that a US-based standard setting board could glom onto. I think a US-only board could probably be set up with the kinds of governance and independence and funding that the SEC would find more congenial than a global board. It's clear beyond cavil, to me at least, that this is a much better way of proceeding than to have the SEC try to develop its own rule book in this area. IFRS announced, I think either earlier today or yesterday, that they're hoping that their standards board will be in business and have climate standards by sometime in 2022. I think by far the most likely way for the SEC to achieve a similar result would be to use some of the existing resources like TCFD that are out there today and house them in some kind of a standard setter. I think there are examples of a standard setting architecture that's been accepted by the SEC and by the markets and that has worked pretty well. The most obvious example is of course the FASB. But a less often talked about example that I think has worked very well for 20 years now or 18 years now is COSO, which the SEC adopted as its framework for internal control over financial reporting back in 2000.
Can you translate that acronym for us?
Yeah, the acronym is of absolutely no utility to you. COSO stands, it's COSO. It stands for Committee of Sponsoring Organizations, which is one of the great non-substantive acronyms or names of all time. That's what it is, the Committee of Sponsoring Organizations. But they have a large level of respect when it comes to the ability to design a control framework. They are widely thought of as independent, even though their funding is not. They are funded entirely or almost entirely by the accounting firms, but they are thought of as independent nonetheless. And they're another example of how you can use the private sector to further a government purpose and government rulemaking. I can stop there if you want me to, Ed. I would say two or three more sentences and then I'll stop. One is, if the SEC were of a mind to do this, I think they should be of a mind to think seriously of the FAF as an organization that might be the umbrella, not within the FASB, just like the IFRS is not doing its board within the IASB, but a separate leg. The FAF has a kind of a proven credibility in the standard as being able to oversee standard setters.
Let me interrupt you again.
Sure.
Give us a capsule description of what FAF is, how FAF relates to
the FAF is
what that architecture is.
Okay. FAF is it's a parallel. FAF and FAF has been IFRS ISB set up an exact level. The FAF is a foundation, nonprofit. It has a board of about 13. It has public sector representatives. It has accounting firm representatives. It
Stands
has
for Financial Accounting Foundation, correct?
Financial Accounting Foundation. It oversees the activities of the FASB, which is the accounting standard setter in the United States. It is responsible for making sure that the FASB has funding. That used to be more of a chore than it is now, because there is an accounting support fee that the SEC collects on behalf of the FAF and passes on to the FAF, and that's what funds the FASB. But the FAF is the oversight board, strategy, making sure that the FASB operates with due process, making sure that the FASB operates with proper levels of independence. And as I say, there's a body of IFRS trustees which does exactly the same thing with that. Using that organization as opposed to creating a new one, that strikes me as a much, if you're trying to move quickly, and I think everybody, wherever we're moving quickly. I think that's just, I don't think you can come up with a better infrastructure than the FAF. And it has the advantage of, frankly, being there and available if the SEC were willing to take the initiative and change the FAF's mandate so that it covered this whole sustainability ESG issue as well as financial statements. The FAF brief today is financial statements, financial footnotes, which is what the FASB's brief is. The FAF and the FASB don't even have authority over MD&A. It's just the four corners of the financial statements. And so this would require an initiative by the SEC that, in my own mind, I think would be well worthwhile.
Terrific. Amy, what would a standard setter need to look like to get the support of CII and its members?
Well, thanks, Ed, and thanks for having me. Last fall, CII's members approved a policy on corporate disclosure of sustainability performance. So consistent with that, that we believe that an independent private sector standard setter should have the central role in helping companies provide investors with decision useful, comparable, and reliable sustainability information. And we think it's important that standards be developed by an independent standard setting body that has deep expertise in the subject matter, for the reasons outlined by many earlier, that the need to, as expectations and the market's needs change, that there can be, this can be dynamic. But it's also important that the standard setting body be at arm's length from companies that have to comply with the standards, the political winds of elected officials, and from regulators. And we think that's crucial to ensuring a measure of independence that benefits all market participants. As others, I guess as others have noted, these are evolving standards. Ideally, I think, and as you heard from many of our members on the last panel, a single global set of high quality sustainability standards is preferable to a patchwork of national reporting standards. But as others, and as Alan most recently have outlined, there are a lot of practical challenges to making that happen. And, first of all, how do we know if we're comfortable with the Global Sustainability Standards Board if it isn't even established yet? We can't pass judgment on it. But we don't need to let the perfect be the enemy of the good. And, I think whether standards are set for U.S. investors come from an international entity or a U.S. body, it's critical that the independent standard setter have adequate funding and adequate funding mechanism, so the funding comes from sources other than contributions from companies that would be subject to the standards. That there also be significant, prominent, and a balanced reputation from investors, qualified investors, on the staff, the board, the oversight board, and any outside monitoring and advisory groups. And also that, there's some public due process to ensure that the standards meet investors' needs in a timely way. These are kind of all we think are critical. if the SEC lacks the statutory authority to endorse global sustainability standards board, perhaps it could have oversight of an advisory committee that would be responsible for establishing and overseeing an independent private sustainability standards board, in the same way as we've heard that the SEC has oversight of the FAF, the Financial Accounting Standards Foundation, which is responsible for oversight and administration finances of FASB. We could go into materiality, which was discussed earlier. I think I hear a lot of different views from our members on that point, but that's a baseline issue as well.
So in terms of the architecture and governance, if a sustainability standards board met the benchmark or the gold standard of FASB and FAF, would that satisfy the CII members? In other words, to take a concrete example, Alan's suggestion that FAF be given authority and funding to have a second track, a sustainability standards track or an ESG standards track in addition to the financial accounting track, and that it acts as the overseer of these now two tracks, the FASB track for traditional financial accounting, and then the other track set up in a similar sort of way. Does that provide a way forward for CII?
Potentially, yes. There's a lot that we don't know. I mean, I think, the source of funding and the assurance of funding that's independent of those who are to be meeting those standards or reporting on those standards is critical. So there's certain basics that have to be established. But yes, that would be one, could be one path.
John White, you were a director of CorpFin. You are very involved with accountants. Start us off with how you see the credibility of accounting standards having been created and whether that model of creating credible standards can be translated into ESG standard setting.
Well, first, thank you for including me, Ed. Well, my easy remark there is leave FASB alone. If we want to have, I think one of the most important things that we have in the U.S. Reporting system is the independence of FASB, and I think that if we added to their mandate really a politically charged area, we run a risk that we would impair their independence with respect to accounting standard setting. Having said that, obviously the FAF, as Alan has described it, is very experienced at overseeing standard setters. You've only referred to FASB, but they also oversee GASB, which is the governmental accounting standards. So this would be a third group, and I actually think they would be an ideal choice to do that. Just as a starter. Maybe I thought Alan did a really good job of taking us through the choices here, starting at the international level. Let me comment a few things on the way Alan took us through it, because I guess I have a few observations on that. My first question is, does the SEC have authority to do whatever it is we're talking about? Or does Congress need to do something? And as we think about all these different structures, if we are thinking that we'll go back to Congress, then so many of the issues that we're talking about here just go away, because Congress can authorize anything you want them to authorize. If we are going down the road that the SEC is going to do this without going back to Congress, that there are a lot of impediments there. I'm not an administrative law lawyer, but I can assure you that you need to think through each step of the way, both authority and cost benefit, as you try to lay it out or sort it out. Mm-hmm. And so I will just have to say, if we're looking at choices, and if I was in John's shoes, I wouldn't necessarily, just throw away the idea of what I'm just going to call traditional rulemaking, where you would, have some mandated line item metrics, and you would have qualitative requirements, including obviously materiality-based ones, because that would be a very, traditional path that's well trodden. It could be done efficiently. You could get, for example, climate standards there and done and in place, I think much more quickly than anything else. And so that it only takes 3 commissioners to vote for it. It would be a way that you could move pretty quickly. I'm very sympathetic to John's concern about, everyone's concern, we've heard it all day long, about keeping up to date and having flexibility. I might just say as an aside, when I arrived at the SEC right after Alan, one of the things I looked at was the oil and gas rules, which had been adopted 15 years earlier and did not allow you to report fracking reserves. You absolutely could not report them. And so the oil and gas reporting was largely worthless because half the oil and gas that was in the ground couldn't be covered by the rules that were set up 15 years earlier. Just to give you an example of how the SEC can put in place rules that become quickly outdated. It took 15 years, but so you do have to figure out how you're going to deal with that. But if John wants to get something done, I would not give up on just regular rulemaking.
Within the existing SEC authority, without going back to Congress, what would the path be for a standard setting strategy?
Well, let's go through what Alan was describing. I guess at the end of the day, I mean, there are kind of two ways you could do it. I get one. Alan described the endorsement model, and he described the COSO model. The endorsement model would obviously be what we would use if the Sustainability Standards Board was set standards, and then we would have here, presumably, a sister of FASB under the FAF would look at standards that came out of the international body and decide if they were applicable for the United States, and could add and subtract those to fit in the United States. That would be the endorsement model, and that, I don't know. To me, Alan, you will come back to you in a second on whether that fits within existing authority, but I'm going to assume that maybe it does. By the way, the funding of that is not enormous. I don't have the exact numbers, but I think like the PCAOB has funding of, I don't know, $300 or $400 million because they, inspect everybody. The entire FASB FAF funding, I think, is like $50 million budget, and like they get half of that from selling the publication. So it's having a sister to FASB is not actually that big, that expensive a proposition. I could even suggest, if you were doing it under the endorsement model, I could suggest it. I mean, it would be a full-time job, but I'm just suggesting it. It's not. It might not even be a full-time job if you were just.
That's a data point. But the IFRS budget is about $40 million.
Okay, so we're not talking about, yes, Alan, we're not talking about large amounts of money. The support fee that goes to FASB is less than 40 because they make all this money off of publications. Actually, I hate to show props here, but when I have, but since they happen to be here, I paid $125 for my 3-volume set of IFRS standards, and that's how they make money. There's no one else. I know there's no one else that has the 3 IFRS standards sitting there on their shelf. And I know that was a play. Anyway, but I'm very intrigued by what we're calling the COSO model. But really what the SEC would do would be laying out in a particular area. Here is what we want to be covered in terms of disclosure, let's just say, with respect to greenhouse gas, or maybe it's a broader subject. And they would lay out some just basic parameters. And then they would say, because this is what COSO says, if you report that information in accordance with a recognized set of standards or an approved set of standards, that's good. You in effect have a safe harbor if you do that. That works. And that's the way the COSO is set up. If you review your internal controls against a recognized set of control standards, which is what COSO has put out, then you're okay. Now, it doesn't say that, and then of course the SEC would, in that process, say, TCFD was approved for climate, or they would say SASB's approved for everything, or, I mean, the SEC would decide who the approved standard setting frameworks were. But it could just be one, because it's just one in the case of the COSO model, but it could be multiple ones. That also allows you to put in, to plug in the what comes out of the Sustainability Accounting Board. I mean, the SEC can set that up as being an approved standard setter, approved framework for whatever you've chosen, whatever the topic is. But as I look at it, Alan, I guess you were there when that was all figured out, how to set up the COSO model. So you've got more experience with kind of the structural issue. But I'm very intrigued by that as a way to do this instead of trying to set up a standard setter from scratch. I just think that's very challenging.
Let me get Alan back in here. Alan, what kind of compliance has COSO induced? Or is it close to 100% that people take advantage of the safe harbor?
Well, yeah, the answer is yes. I mean, it's actually what John said is pretty interesting on this point. I want to come back to the authority point in a minute, but the specific question, the adopting release on internal controls provided that a company could pick an established framework for internal controls and or an approved standard, an approved control framework, and the company would then test itself against that framework. The release, and I think the rule, although I don't remember, approved COSO. But it's very clear in the release that the SEC, that we at the time contemplated the possibility of alternative control frameworks that a particular issuers might use. There were actually two that we specifically had in mind, and the release I know mentioned at least one of them. And that was there was a possibility that there was a framework that was in use outside the United States that was not COSO that could have been used by foreign private issuers. It turned out that didn't happen.
But you're right, Alan. It was very much disclosed as a choice.
Sorry?
That was very much disclosed as a choice of how it could be applied.
And the other one was, we were really hoping, because COSO is a big company framework. COSO is a Fortune 500 or Fortune 250 framework. And we were hoping that a framework would be developed that would deal with the lower 80% of public companies by number, not by market cap, but by number, because the rule didn't exempt smaller companies. We temporarily exempted smaller companies. There was no appetite to permanently exempt them in 2003 or 4. They were later permanently exempted, so the problem went away. But there was always the possibility when we were doing stuff that we wanted somebody to come up with a framework for a smaller cap company. So,
and what is the internal SEC?
This would be the SEC X meets the standard, but we're open to the possibility that Y does also.
And so what is the internal SEC process that's anticipated there for scrutinizing these external standards and endorsing them?
The process was embodied in the release and in the work that went into adopting the rule. I will readily admit 2004 was a kinder, gentler time for regulators. But
is it a one-time approval? Is it a one-time approval or a periodic approval?
It's one. Well, it's actually, it was, the answer to that is mixed. It was approved at the time the rule was promulgated. It was not contemplated that there would be a subsequent periodic approval. COSO actually changed its framework since 2004, sometime around 2011, as I recall, or 12. And the SEC put out a release. It was not a rulemaking, and I actually don't remember whether it was a commission release or a staff release, but approved the new COSO framework as the successor to the old COSO framework, and indeed gave companies a couple of years to measure themselves against the new framework if it took them that long to figure it out. So the answer is not quite either one, Ed. But the COSO was not, the use of COSO in 404 was never challenged in court back in 2004. So there's no case out there that stands for the principle that the COSO solution was authorized. I'm a firm believer that it should withstand scrutiny. I think the way you test it is the way you test the SEC's own rules, which is there a robust APA compliant, cost benefit compliant analysis that supports the choice of COSO?
But I mean, Ed, the way you would do this is you would lay out that you want greenhouse gas disclosure that covered the following topics and did the following things. And that would go on for, I don't know, I'll say several paragraphs or more. And then you would mandate that companies had to provide that disclosure in accordance with a recognized framework. And then you would go on and recognize whatever, at least one framework on day one, or maybe more than one. But once you recognized it, it would stay recognized until you unrecognized it, or you could add other frameworks.
Yeah. Amy, let me turn to you, Amy. How does that strike you in terms of the process? It's not the robust supervision model of FAF and FASB with the protections that you were talking about, but it would be a way of getting there in what John refers to as the endorsement model at least within current practice, if not immune from challenge.
I think it's that standards, if there is sort of an endorsement of existing standard setters or existing standardized frameworks that are widely used.
The endorsement model is the way you pick up the what comes out of the.
I'm sorry, I meant the
COSO model.
The COSO model,
yeah,
where you say companies have to disclose about greenhouse gases, say, and that it's a safe harbor if you disclose comply with a framework set up by an external body, and in the adopting release, you recognize a number of external bodies, but as described here, there's no ongoing supervision of the external body. There's none of the demand that you had articulated before for independent funding. They're funded however they're funded, and they provide the standards that they provide.
Well, that's potentially it sounds great, but it's potentially problematic. You don't know where's the money coming from, what's the source of the funding. That's really a critical question. Can the SEC do this if it has no jurisdiction? I guess you've already answered that, but I know that's been an open question.
By the way, I think part of your requirement would be that if you're going to go off to a framework, that has to be a framework that has certain, I don't know, we'll call them independence, due process, funding things built into it. And the SEC would conclude that whichever framework you've chosen had those, it would conclude, and that, you know, obviously it had to maintain them.
Yeah, and Ed's point is correct that the SEC would have to act to remove the authority, but the SEC, I don't underestimate the practical problems, because if you designate a standard setter and then the SEC decides that the funding and the governance is no longer appropriate, can it pull the authority? And the answer is yes, it as a pure authority matter, my view is that it could, but it would cause any number of practical difficulties if you've got, you know, umpteen hundred or thousand U.S. issuers using the rule. I mean, we thought about that in the case of COSO. What happens if COSO falls apart? And the answer was, honestly, the answer was we didn't really have a choice, and so we took the plunge. But I don't, you know, I don't negate the concern you're raising, Amy, and the concern that you're raising, Ed. There is one. The other thing about the standard setter, Ed, I think it's important. The standard setter doesn't set the trigger for disclosure. The standard setter says, tier one,
how you do it.
Tier two, or how many whatevers. It's the SEC that would say, either in the manner of its traditional line item disclosures, it's mandatory, including whether it's material or not. They could also say a company has to disclose if it triggers the 10b5 threshold, materially misleading to leave it out. The SEC could say it's mandatory if it triggers the existing or some other MD&A forward-looking statement trigger. So I think it's important. You would not, I certainly would not leave to the standard setter the decision as to what disclosure is mandatory as opposed to what the yardstick is.
Right. That the standard setter sets how you disclose, but the SEC determines that you have to disclose, whether you do or not.
And the SEC would also be the reviewer and the enforcer. And to somebody's point earlier on this panel and on an earlier panel, going the standard setting route does not solve the SEC's problem that it is not currently fit for purpose in the ESG area. They are going to have to staff up in order to enforce their rules, in order to review the 10Ks and the 10Qs. And this might give them another 2 years to do it, but they shouldn't think that they don't have to hire anybody if they hire Janine.
Let me turn to Janine. We have only a few minutes left. Janine, does the COSO model, as Alan describes it, does that provide an interesting way forward for SASB?
Yes, I mean, we have advocated for the COSO model for some time. If you go all the way back to our 2016 comment letter on the Reg SK concept release, we advocated for the COSO model. I think the one really important thing about the COSO model that we haven't delved into is the criteria, what we say, and we will say this in our response to the SEC's consultation. We think setting out the criteria for an acceptable standard setter is really, really important. And then the key question is, what is the SEC diligence or oversight around assessing compliance with those criteria? And that may not be something, call it heavy and current staff or even oversight model, but there needs to be some process. And we're going about what.
I would just throw in that, I mean, today the Office of Chief Accountant basically reviews everything that the PCAOB does and everything that FASB does before, you know, it has any real impact on things. I mean, the SEC does, there is a structure for the SEC staff to oversee both of them.
Well, this has been an absolutely fascinating discussion. I think we've provided the SEC with a way forward. The COSO model sounds like a very promising model, subject to figuring out A, what needs to be disclosed, B, a robust set of criteria for certifying, for accepting external standard providers, and C, as John points out, to have some ongoing supervision of the products of these groups. We are out of time. Our next panel is going to address what's going on from the issuer perspective. But first, please join me in thanking our wonderful panel for this wonderful discussion. And then let me turn things over to David Katz for the next panel. Thank you.
As we get our other participants to put their video on and unmute, we have the last panel of the day. It's called Issuers, What Are Forwardly Thinking Companies Currently Doing? What challenges are they facing? And can the SEC help bring order to a chaotic situation? We've got 4 terrific panelists today. Alex Sahabian is from Hess. He's responsible for leading a global team of environment, health and safety functional specialists, providing thought leadership on emerging issues for senior management, developing trusted partnerships with key stakeholders, and strengthening the sustainability culture enterprise-wide at Hess. Yep. Next is John Finley of Blackstone. John is Senior Managing Director and Chief Legal Officer of Blackstone, a member of Blackstone's Management Committee. He's also a member of the firm's ESG Steering Committee. Before joining Blackstone, John was a partner with Simpson Thacher & Bartlett, where he's a member of that firm's Executive Committee. Rudy Blass, he's a Chief Accounting Officer at Bank of America. He's been the Chief Accounting Officer for 20 years at Bank of America and previously at Credit Suisse. Prior to that, Rudy spent 20 years with PwC as an audit partner in the financial services area. Rudy chairs the Financial Executives International Committee on Corporate Reporting, which is made up of 50 chief accounting officers from Fortune 100 and other large public companies. Rudy is also a board member for SASB Foundation, and he also serves on the Financial Accounting Standards Advisory Council of the Financial Accounting Standards Board. So, and our last but not least, we've got Maria Gazelle. She's a Senior Vice President and Counsel for the Business Roundtable, where she directs strategic initiatives for the organization. And most importantly for our discussion today, she oversees policy development and advocacy for the BRT's Corporate Governance Committee and is the BRT's chief advocate on these issues. So we really do have a terrific panel today, and we're going to jump right in. I'm going to start with John Finley and sort of ask if he can give his perspective of what the SEC should do and not do.
Thank you, David, and thank you, Ed and others for inviting me to this. Very proud to be part of this august group, and I've heard some really great thoughts participating from the start. It's been an excellent conference. I'm going to assume Ed laid the premise that the action is going to be taken that's going to go beyond the existing disclosure, or at least a great effort to do that. And you want to get our best thoughts, both with an asset manager and an issuer. So I'm on the issuer, which makes sense because we're also dealing with it from that perspective. But my thoughts really are my own at this point, not Blackstone as an institution, because I view this sort of as a working session, and we're sort of working through some of the issues here. So where's Blackstone? Blackstone's ESG program, which has been central really to our mission of delivering strong returns to our clients, has been materially enhanced over the past couple of years. We've always, going back to 2014, we were already having ESG memos on each of our investments. But in the last couple of years, we've really focused on targets, portfolio company engagement, reporting. We've been responsive to our fund investors, some of which have high expectations on ESG, not all. And we've looked to meet the expectations of employees, communities in which we operate. In terms of our targets, we've really tried to leverage the Blackstone platform for certain signature programs, emissions reduction targets across all new control investments, diverse representation on portfolio company boards, pilot programs designed to recruit candidates from under-resourced communities, supplier diversity, and we publish an annual ESG report. We have a robust control process for the publication. It actually is integrated with people from finance. I heard something earlier today. That's something that sort of developed as people noted is appropriate. We're definitely enhancing our data collection across Blackstone's corporate and across the portfolio, and that's a critical issue, the data collection for someone like ourselves. There's enthusiasm really for the teams to continue to integrating ESG into our investment process and asset management work. Feel that there's really a good buy-in across the company. You may have read very recently we hired Elizabeth Lewis to implement ESG policies across Blackstone. We did same time we announced 4 other hires. I mean, this is a very active group and we are all in. Just to hit one of the challenges, we support the recommendations of the Task Force on Climate-Related Financial Disclosures. You've heard the acronym TCFD, but that's actually been a challenge for us because it addresses climate disclosure across all our underlying assets. And so for Blackstone, this requires an extensive data collection effort across an eclectic mix of 200 plus private and public companies and 8,000 real estate assets. And the complexity is exacerbated by constantly changing mix of portfolio companies. Obviously, we're in the business of buying, selling assets over time. So given the targets we've established, and we have an extensive effort to collect that data, we have an intent to report as soon as we have comprehensive and accurate information. The technology that will be available to us is just going to be critical. And we're piloting several applications, but the data technology specific to this space is still developing without a clear winner. So it's a good example of the need for looking at different sectors, different companies, how they deal with their issues despite the best of intentions. So from an issuer perspective, where would we like to see things go? Let me give it in summary fashion. In accordance with the SEC's mission, which is protect investors, enhance capital formation, promote efficient allocation of capital, my view is the SEC should focus on setting standards, particularly with respect to climate. They should leverage SASB and TCFD to achieve consistency rather than prescribe a detailed code. The establishment of standards, however, in our view, should precede the metrics to make that reporting effective, because you can't set disclosure of profits and cash flow without first establishing accounting standards. And we won't achieve consistency and comparability without a broader context of why a number is important. And let me give some specific recommendations along those lines. There's an issuer confronts today an alphabet soup of disclosure standards for ESG, both in the US and abroad. And issuer investors could benefit from consistency and comparability. So that would be point one. And certainly it would promote, as I think one of the earlier speakers said, an efficient allocation of capital. In assessing the standards, the advantage of leveraging SASB and TCFD is that many large corporate issuers are already incorporating this standard in their public reporting or otherwise referencing it. And for our corporate disclosures, these are the standards on which we're most focused. And some of the other advantages of using, we've talked about SASB, you do have some, if this were ever to happen, change of administration in the future, you have a little bit of political insulation with a standard setter like SASB. It's already here, SASB, so you have a resource issue. In terms of speed, again, the admonition of John Wooden, be quick and don't hurry, it will help to move things along, given that SASB's already been formulated. It's flexible, to use John Coates's about the speed limit. Yeah, you have to deal with different circumstances on the road. Is it an emergency? Is it raining? Whatever. But you also have to deal, which maybe you don't have to do with the speed limit with dealing with this area. The road may change and the road goes in a different direction because it's much more fluid than a road. And that really wanting to make it dynamic with a standard setter. The other advantage of a principle-based approach that leverages these as standards is that it can be sector specific and grounded in materiality. And information that is, as we all know, substantially likelihood that a reasonable investor would consider important in deciding voting or investment decisions. Again, either voting or investment decisions. And I think David did a great article on this published yesterday. Departing from that standard, I think would be a historic mistake. Really need to stick with a historic definition of materiality. And I think within that existing definition, there'll be plenty of flexibility to do what we need to do. I would say that with respect to materiality, on our analyst calls from our shareholder investors, we've never gotten a question on climate from our analysts. Having said that, and the investors in our private funds are engaged in these issues, although they're generally addressed through sustainability reports and diligence. I'd also say that there's no reason to be cynical in looking at where the private market is moving. This is not so much to say that you need to rely solely, to make the argument, rely solely on private market, but not to be so suspicious of it because the market is moving along faster than anticipated. I took a quick look of the top 25 S&P companies by market cap, and every company is now providing an annual quantitative and qualitative assessment of ESG practices. 84%, well, I should say 84% are tracking at least one of GRI, SASB, TCFD, and or UNGP and SDGs. 76% are tracking TCFD. And I think we'll see over and over that things have moved quite a bit. A KPMG survey that just came up said in only 5 short years, attitude towards the financial risks of climate change in the financial and corporate sectors have changed beyond recognition. So we don't need to be cynical about what we can rely on in the private market. SASB setting standards by sector is welcome, certainly by me because of in working with representing asset manager with a very diverse portfolio, the approach would be tailored, and they have 70 sectors they look at. So having standards that would work both for ExxonMobil and Salesforce, having this differentiation is critical. I'd say the ideal model, I heard the COSO model, I would say the ideal model would be using SASB on the model of FASB, which could allow applicability. That would be simpler in terms of the SEC not having, in the absence of an SEC opt-out, it would apply. Obviously, this is time consuming, and so there may be better alternatives, things that need to be done in the interim, but that probably on the model of FASB might be the most effective, although as we talked about, in lieu of congressional action, the SEC could create safe harbors for certain standards based on the precedent. I mean, one other precedent is on the pay equity ratio. If you sort of comply, you're within that standard. But I think this notion of safe harbors is a terrific idea with leveraging what's already out there. 2 final thoughts. Whatever is done, I think it needs to be very careful with transitions and exclusions for small issuers. Private companies should not be covered any more than they are today for things like cyber disclosure. And finally, establishing a global standard, I just think is impractical. And we should deal with the EU model today as we deal with FASB and IFRS. We should continue to emphasize our model based on transparent rulemaking removed from the political process and materiality and engagement with the investment community. But again, we're looking for speed. We're looking to move things along. Trying to do a global model won't be practical. So with that, I'll turn it back over to David.
John, one quick question. You obviously have both public and private companies in your portfolio. Do the private companies go through the same analysis, and does that get baked in, or how do they treat these types of issues?
Well, there's two real issues here. One is for our reporting, we need to do data collection. So we need to collect the data from our portfolio companies. Each of our portfolio companies needs to have their own ESG, needs to think about its own ESG policy. And in fact, over a period of time, and we're still in transition, exactly how we articulate that policy, as with other policies, whether we're telling them what we think about cyber or FCPA, climate may be another area within that. We give them assistance and facilitate how at each board level, and our own people who we've done ESG training with, how that leadership should be done on climate, and working with our asset management and portfolio operations teams.
Okay, thanks. Alex, do you want to talk about what Hess does currently, and what you think some of the difficulties and frustrations are, and how the SEC could perhaps help you achieve those goals?
Yeah, sure, David. Hey, and thanks for inviting us. And John just shared a lot of really great information, so I'll probably build a little bit on that. But first of all, I think I'll speak maybe more generally. I think companies already understand the value of consistent and quality ESG disclosures. For instance, Hess has been voluntarily providing that information now for 23 years. So if I really look at the framework of how we handle our disclosure, I would say that it's beneficial for companies, first of all, to conduct some sort of assessment to determine what is important for their stakeholders. And I think that's where it gets into, specific industries, for instance, and understanding the different complexities. We disclose that in our sustainability report. So we describe the process that we use to do that assessment. But we probably do that about every 5 years or so, depending on, if issues or things are changing, for instance, in our portfolio. But the other thing that we do is we do a lot of ongoing stakeholder engagements, and we do a lot of ESG surveys just so that we can continue to understand the interests and concerns. So the other thing is, John mentioned the TCFD. So I think it is important for companies to follow some sort of management framework. TCFD lays out elements for governance, strategy, risk management, and metrics and targets. So I think it's good to talk about how companies are managing these sort of risks and climate risks in an established framework. So whether it's TCFD or some other framework, I think that's very beneficial. And then last is the whole notion of reporting frameworks. So we follow GRIR, but we cross-reference the UN Global Compact. We cross-reference SASB. And then we also follow industry-specific reporting standards, like in the oil and gas industry, it's IPICA. So that just gives a general approach of how we do it. And I think a lot of companies probably follow a similar approach. I will say the quality of reports and the quantity of information provided has certainly increased over many years. I know when I go back and look at our early sustainability reports, they were almost like a pamphlet, and now they've become, quite mature and complex. And I think, ultimately our approach is we try to provide as much information so we can cover as many stakeholders as possible. That being said, then you mentioned some of the difficulties. I think for sure too many standards. It seems like standards kind of pop up all the time, and it's understandable that different organizations want to have kind of their footprint on what's being asked. But I think moving towards some sort of integrated standard, or some sort of standard maybe that starts with the US and then moves to an international, I think would be helpful. And then also mention is that we do a lot of ESG surveys, and having to correct a lot of information on that surveys. I think Adrian from Vanguard mentioned that it can take up time and be a little bit frustrating. So John also mentioned like complexity. So I would just say, understanding the complexity of reporting, and especially when it comes to metrics. I'll just use climate metrics, for instance. When companies talk about climate metrics, they could be talking about scope 1, scope 2, scope 3 emissions. They could be talking about operated, non-operated. They can normalize by certain production factors or not, not normalized, depending on the reporting boundaries. It could be upstream, midstream. So there's just a lot of complexities involved in the metrics themselves. And that's why, if there is a move to move to some sort of standardization, that you really need to involve multiple stakeholders, including, industry, to make sure that those things are going to provide the necessary quality from a reporting. So, ultimately, what could the SEC help to make it better? I think this has probably come up several times now throughout all the panels, but, I guess my perspective would be that there really is not a need for the SEC to create anything new. However, I think if the SEC could support ongoing consolidation efforts, I think that would be very, effective. Mr. Coates described convergence with existing standards, and I think that would certainly help to move towards one set. So I know it's fairly brief there, David, but I think a lot of what I've talked about, probably others have already talked about, but I think ultimately the kind of the quality and the transparency will improve, I think, with just continued improvement around the reporting standards themselves. So,
Alex, you mentioned mostly about sustainability and climate. Do you try to cover human capital issues and diversity, equity, and inclusion issues as well?
Yeah, so that's it goes right back to one of the first points I made, which is kind of almost like your materiality assessment, and we'll describe that in our sustainability report. But we really use that as an opportunity to look at internal issues, internal stakeholders, external. We do a lot of desktop reviews, and then from that, we'll identify issues that we know are important to our stakeholders. Certainly, diversity and inclusion has surfaced. So previously, our last 5-year strategy may have not discussed that in detail in our sustainability report, but that will be an issue now that we describe in detail based on our materiality assessment. So I think it's just recognizing that as things evolve, that there needs to be some dynamic way of understanding those risks and being able to, address them. And that's why having this ability to do some ongoing assessment and also engaging with stakeholders, helps us to understand what are those issues that our stakeholders want us to report on.
So when you talk about, if they're material enough from materiality, are you looking at it from a Hess shareholder perspective, or are you looking at it more broadly?
Yeah, when you say shareholder, I mean, I think obviously shareholders are a very important stakeholder for the company, but we look at it more broadly. So we'll look at it possibly from a government standpoint, from a host. It could be a host government, it could be a U.S. government. Certainly from even just having ongoing conversations with institutional shareholders, for instance, but even things that we may get from questions that are being asked of us from just communities where we operate. So I think it's a little bit more inclusive.
Okay, thanks, Alex. Rudy, I know you're very involved and engaged with a number of your chief accounting officers across the globe and across different industries. Can you share with us some of the main themes that you think are being discussed? And, to the extent that you want to work in how Bank of America approaches some of these issues, feel free.
Yeah, so thanks, David, and have to admit, I'm thrilled to be here as well. As you said in the intro, I chair a group of about 50 chief accounting officers. And I would say the topic of ESG disclosures has certainly been a hot topic amongst that group of late. And you need to remember, the chief accounting officers is the area in companies that is responsible for preparing the recurring SEC filings like the 10Qs and the 10Ks. And I have a number of themes to share with you all. But before I share the chief accounting officer point of view, I would be remiss if I did not share the Bank of America enterprise perspective on this whole topic, especially given how outspoken my chairman has been, and also with respect to his work on the IBC with the WEF. So first to that overall view, Bank of America welcomes the interest of policymaking bodies to increase attention to ESG issues and further catalyze the discussion around disclosure standards for non-financial information. We believe that businesses that measure ESG impacts and integrate them into corporate strategy will spot risks and opportunities earlier than the competition. So it's that simple. We also believe that companies that align their goals with the long-term goals of society will be more viable and valuable in the future. Last fall, as you all saw, the WEF IBC proposed 21 core metrics across 4 pillars: people, planet, prosperity, and governance. All of those 21 metrics were derived from existing standards. All agree it will take time, and the WEF and the IBC have encouraged companies to begin disclosing now in order to increase the collective understanding of what can and should be done in this respect. The idea is for the WEF and the IBC set of metrics and disclosures to serve as an asset for others to work with. That is a building block of developing globally accepted standards. This initiative was designed to offer comparability and consistency across regions and industries, and to offer a possible baseline drawn from existing standards. On this first point, I would add it is encouraging to hear all the statements from the SEC and the efforts of IOSCO to support the engagement with the IFRS process. Finally, I would add that we in the banking industry think it is very important that the SEC work closely with other government agencies to, for example, bank and other market regulators. So with that said, let me move on to the specific perspectives of chief accounting officers. And those are the people that roll up their sleeves and prepare the SEC periodic financial filings. The way I think of it, what I will talk about are the prerequisites to the SEC mandating ESG reporting. And these are the top 5 themes that I am hearing. The first theme is what I refer to as common understanding. So you heard it along the way today. Traditional financial reporting has evolved over many years with many stakeholders around it: preparers, standard setters, educators, lawyers, auditors, consultants, and such that there's a high degree of common understanding of what a particular disclosure seeks to convey. ESG reporting is far from that. Therefore, a measured approach over time is needed to allow this common understanding to develop. The second theme I'm hearing is with respect to the variety and the nascent state of the standards already out there. A critical prerequisite to requiring disclosures is clarity on those requirements. This requires established standard setters with a proper mandate that develops standards applying due process with full transparency. I would observe that the existing disclosure frameworks have been developed with less than full participation by the broad stakeholder groups that are needed. I would add that SEC guidance should be principles-based and focused on encouraging companies to disclose material risks, including all material ESG risks. No need to start from scratch. We would encourage the SEC to consider existing disclosure frameworks such as TCFD and the SASB, as the chief accounting officer believes that a principles-based approach can be supported by reference to such frameworks. The third theme I hear from chief accounting officers is with respect to processes and controls. And you can throw data in there as well. In many organizations, the processes and controls supporting ESG disclosure preparation have been developed outside the finance function and have not necessarily been subject to the same level of scrutiny that SOX requirements have driven for financial reporting. It will take time to retrofit those processes and controls to the same level. I hear CAOs saying they believe that ESG reporting, as a matter of best practice, should be governed and have controls similar to those applied to financial reporting. So that's really good. I also hear that for most companies, that will require investment and time to achieve. Further, certain ESG disclosures will be based on external data sources and as such will not be verifiable by company management. The expectations over internal controls with respect to such disclosures needs to be calibrated to consider the aspects that reporting companies can control. The fourth theme I would share with you is materiality definitions. We heard a few times during the day. I would, to state the obvious, there is confusion about materiality and how it should be evaluated in the context of ESG reporting. As preparers of financial information, chief accounting officers apply the investor-focused concept of materiality as defined by U.S. SEC's law when reporting under U.S. GAAP and SEC requirements. To provide consistent and comparable disclosures for the SEC's target audience of investors, we believe that the Commission should support the application of this same definition of materiality to any proposed SEC required disclosures. The The fifth and final theme that I would share with you is with regards to timing of reporting. Certain information, like emissions disclosures, the scope 3, are based upon information external to the company. It may not be feasible to obtain the information within the existing SEC timelines. So that's going to need some reconsideration. So, David, I would stop there.
Okay. Rudy, I think that's very helpful, and I think we'll come back to some of these topics and themes as we go through a few questions. Maria, unlike the three companies, Business Roundtable gets comments from a lot of different members, different industries. What are they saying about ESG disclosure? And from your perspective, how can the SEC help them through rulemaking and guidance?
Great. Thanks, David. And I'm also delighted to be here, and I've learned a lot today. This has been a terrific day. So just a reminder of a Business Roundtable, the members are the CEOs of America's top roughly 200 mostly public companies. They operate in every sector of the economy, every region of the country, and throughout the world. And so we're currently going through, like many others, the process of preparing our response to Commissioner Lee's request for information that we've been talking about all day. And we're wrestling with many of the issues that we talked about. Our operating principle and how we're looking at everything is that our members are deeply engaged in this, in our developing our response. They're approaching the issues with a great deal of openness and a desire to be constructive. So I just wanted to say that. But that said, of course, this is very, very complex space for issuers. As John and others have talked about, many of our members already, in fact, most, I would say, already voluntarily report ESG metrics, but their approaches, of course, vary across industry sectors and across even companies within sectors. So companies do want flexibility to tailor their disclosures to the circumstances of their industry and their company. But at the same time, you asked what would be helpful. At the same time, they would welcome some order in the ESG reporting space, and they're open to considering some standardization of metrics. Has already been suggested, though, it's a difficult balancing act to achieve this orderly reporting framework and still retain the flexibility that companies want and need to match their diverse circumstances. So, just going into a little more about the ESG disclosure is challenging. We really do think that this is because the space is complex and rapidly evolving. And then the relationship, of course, sometimes to the bottom line is complex, and its importance to shareholders, investors, and stakeholders can be highly variable. I think that was also covered throughout today. So I guess, David, our advice to the SEC would be to start with proceeding very deliberately and gather as much input as possible, which I think they are intending to do before making any decisions. John mentioned the SEC's mission, and we've been thinking about that a lot as well. Of course, the mission is to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. And we do think that this is an excellent set of principles that the SEC should keep in mind as they look to possibly craft ESG disclosure requirements. We think that if the SEC stays true to its mission, rather than trying to solve important societal goals through disclosure, that will really help end up with an approach that will be decision useful information for investors, and that would serve everyone well. So just to go into some of the more specifics, we are approaching this, looking at we would support a largely principles-based approach that delivers the information that investors need in a way that still remains consistent with the traditional SEC approach to disclosure requirements. And then moving on to some of the specifics, we also don't think that the SEC should start from scratch. We do think it would be helpful for the SEC to recognize that issuers have spent a lot of time and money on disclosure already. And there would definitely be a concern if we started just from square one. Our members do think that the SEC should, to the extent possible, leverage what we've been talking about, the voluntary frameworks and standards to inform its work. And that includes considering private sector industry standards that have been developed specifically for climate-related disclosure requirements. Of course, at the same time, in discussions, issuers are concerned about, the prospect of SEC rules that would require companies to comply with a standard set by a standard setter that isn't subject to SEC oversight. We do need to think about that, and it's a complicated balance. We don't want to lose all the work that's been done. It's very helpful. It's great work, but we also don't necessarily want to turn disclosure mandates over to an organization whose standards are not subject to the normal notice and comment requirements that we have today when rules are promulgated by federal agencies. So that's something that we think needs to be thought through very carefully. A few more issues, David. Liability, it was mentioned earlier today, and we do hear issuers are concerned that any new disclosure requirements could lead to increased liability. I've heard John Coates mention that it shouldn't, and so that we do think that that's an important consideration, and to ensure that it doesn't lead to increased liability, perhaps that should be addressed preemptively. Placement is another issue, and I can't compare to have the expertise of Rudy of where things should be placed, but we are thinking through these issues such as where any new required disclosures should be placed, and should, for example, in SEC reports or outside the reports, furnished versus filed. Those are all issues that we're getting feedback on right now from our members, and then the timing. We've heard a few times from our companies that any required disclosure should have an extended timeline to allow issuers to focus first on the financial filings, and then if there's climate-related disclosures, that would come second, and that would be very helpful with compliance costs and then burdens and complexity of how to do all this. And then verification. That's another very important topic, but we are, as we dive into this one, we also are finding this complex that we do think it's important that if there's any type of mandate for verification, it should recognize that what are the standards right now for verification, and then of course the potential for added costs as we move forward. And then finally, this is getting to the end of everything, but there should be a big emphasis on compliance, that there should be enough time that, we understand there's a desire to act, and we understand there's, a desire to act quickly, there's an urgency, but it's really important to make sure that companies are given enough time on the other end for the compliance side. So those are all the things that we're thinking through right now.
Do you think, Maria, that this should be like they're pointing towards some type of annual disclosure, but maybe not in 10K or something like that if you're worried about timing? I think one of the worries that people have about something like that is it's not very helpful if your report comes out in June and you talk about, the year that ended in December and you don't have anything that brings it up to date.
We're thinking through what to recommend on that, David. I mean, it's hard. We're hearing some concerns.
And those are real issues, obviously. Now that we've sort of laid out the initial perspectives, let me sort of go through a few topics that I think are going to be important to the SEC and helping to put stuff together. And the first one, Rudy, I'll ask you to address it first, but I'd like everybody to jump in, is, what do you think would be the worst thing that the SEC could do here, and why would it be so bad?
Yeah, so I think well, let's try to say it a little bit positive. I would certainly caution the SEC strongly against being premature in mandating inclusion in SEC filings. And it kind of mirrors what Maria said before. There needs to be a common understanding, like I said before. Also, companies need to have the time to embed the right level of processes and controls. We also need clarity on materiality. If you're too fast, and that's a lot of wood to chop, by the way, So I would say, if you do it wrong, it's going to cause a lot of confusion as to the meaning of the disclosures. It could take the discussion in a very wrong direction, and potentially expose companies to unneeded added legal exposure, even if people are all just trying to do the right thing. So I would leave it at that, David.
Alex, what do you think?
Well, one thing I was thinking is if it becomes so prescriptive, you might actually lose some of the qualitative aspects of what companies are already doing. I mean, we spend a lot of time collecting data and validating the data, making sure the data itself is of quality, but there's also lots of qualitative information that we provide that I think provides, important context to the people that are reading our reports and are interested in the issues that we're dealing with. So I just think if it becomes too prescriptive and only, data focused, you may actually lose some of that and lose something that's already, that's valuable to the reader. So.
John?
Yeah, so mine would be to avoid a one size fits all. I mean, that's one of the appealing aspects to me of SASB with 70 plus ways in which they address industries. And you've got so many different relevance for the disclosure that would be appropriate, that would be a real concern, and why I think leveraging what's out there is going to be very useful, because I just don't see the practicality of coming up with really useful metrics in a context that's useful without using what's out there already in a time frame that is contemplated.
You mentioned Europe earlier. Do you think that the European approach is too much one size fits all, because it tries to?
I just think it's too prescriptive. It's too Napoleonic code, that and that's really my concern in going in that kind of a direction. It's good for their system, works well with their system, but in the way in which our law is developed, our principles have developed, going in that direction, not going to work. And we saw you've never been able to get the international standards on accounting. We work with sort of IFRS and FASB, and I think that's a good example to think that we could be able to come up with a global standard on ESG when they haven't been able to do that on accounting. Seems very, very challenging.
Maria, any thoughts from you on this?
Yeah, just one, and I guess we would, because we keep hearing about the urgency to act, we would just, one bad result would be if the SEC takes the path of acting so quickly that it issues, interpretive guidance that effectively mandates a whole lot of new disclosures. And that would, of course, leave us out of, the opportunity to weigh in. Hopefully that's not on the table, and it's not what the SEC is looking to do. But, and it also leads me to underscore that I think issuers in general, and speaking for my own members, we want to make what the SEC, we would approach this from how do we make something workable and point out in a constructive way. So hopefully we have that right process.
So when you say the right way, you want to see meaningful disclosure, right? You want it.
Well, no, I meant more from a process, David. Like we want to be able to have comments, notice and comment and all of that, not just guidance.
Okay. John, I'll throw the next question to you first, but assuming that the SEC has authority, which I know there's some people on the phone would disagree about, should the SEC try to have some mechanism to require private companies to have some type of consistent ESG disclosure requirements, or is that going to be too difficult or go to a bridge too far?
Yeah. So taking your assumption, I'd acknowledge the anti-fraud rules and enforcement can be applicable to private companies, but there is a dividing line between public and private companies for SEC mandated disclosure. And whatever the policy objectives of climate disclosures might be, these, I don't think, can fairly be addressed by putting the burdens of public company disclosure on private companies. Private companies simply don't have the resources and infrastructure to be as well positioned as public companies to bear these incremental burdens. And I don't think it's fair to put them, when they don't have the advantages of being public, to then put these burdens. It feels like it's leveraging the SEC for a public policy objective by putting these on private companies. And it's just well outside its defined and well understood role in protecting investors and capital formation to impose these on private companies.
But don't you worry, though, that that will put an even greater amount of pressure on public companies with these disclosure requirements, perhaps as an excuse or otherwise, to go private?
Yeah, well, you've seen the shrinking that's going on for years. There are a lot of forces that are driving that. I wouldn't feel that climate disclosure is going to really change that mix, because there's, as you know, there's a whole series of fundamental changes in finance and how you raise money and investors that's driving that goes beyond the burdens of climate disclosure.
Rudy, any perspective on, should we be trying to have private companies make similar disclosures? Because if you're looking at this from a societal perspective, if you just put the burden on public companies, you're only looking at half the story.
Yeah. And that's the obvious point. And John makes a lot of sense with his comments. The one pragmatic point I would make, again, because I work at a bank, is with respect to the scope 3 disclosures, financed emissions. So we have lots of clients where we're, either lending money or, facilitating their equity stack, and if they're not disclosing, I don't have a chance of doing a comprehensive scope 3, financed emission disclosure. So being very pragmatic, there's some other challenges if you leave all the private companies out of the picture. I'll stop there.
Yeah, the only thing I'd also add as a follow-up, David, is if you felt there's a societal, political, social desire to do that, then Congress is probably the right area. I wouldn't think it's a good idea, but Congress is the right place to do it, rather than the SEC doing an unprecedented act of disclosure to fulfill that societal role that's separate from the disclosure, capital formation.
Yeah, I think that, from a conservative perspective, that's obviously the safest way to go. But I think some of the concern is that may take 2 or 3 years. And do we really have that amount of time to wait on some of these issues? Alex?
You mean specific to that question, David?
Yes. Some of your competitors are private and don't have the same, disclosure obligations. Obviously, they may have lower costs as a result of it.
Yeah, I mean, it's hard. I tend to think that the lifting tide or the raise, lifts all ships. But I think a lot of that's already coming from stakeholders. I mean, especially in the business that we're in, oil and gas, that gets a lot of attention from a climate standpoint and from a transition standpoint. So I think companies, whether you're private or not, I mean, the level of reporting, even within our peer group, we've seen increase dramatically. So I think there's already societal, demand and pressure there for reporting. That's why I don't know that mandating as much as just trying to standardize is maybe a better approach.
Maria?
So the majority of our members, of course, are public companies. So as we're going through the questions and policy, we're really focused on that this would be required for everybody. We really haven't gotten to the question that you've asked at this point.
Okay. Alex, you like many other public companies, have international operations that have to deal with being subject to multiple jurisdictions' ESG disclosure requirements today, some of which may be in conflict with each other. And, certainly the prescriptive things that Europe is requiring makes life difficult if you're trying to, fill out a US or an Australian or something else to sort of make it comparable. How do you deal with some of these that are in conflict, and what role do you think the SEC might have in trying to get them together?
Well, first of all, you deal with it very delicately, I guess, but in all honesty, I mean, it's taken us years to build our reporting database, but we take the approach, and maybe for companies that are getting into this space, is to take the approach that your sustainability reporting should be as broad as possible, so that all other reporting that you do comes out of one data set, so that you're consistent in any use of that data. What I might mean by that is, even if you look at our greenhouse gas reporting process, we report very broadly, even though for regulatory purposes, for instance, in the US or Denmark, there may be very specific reporting. It's much more narrow. So we take an approach that we try to make it as broad as possible, and that can then feed things like ESG surveys or even regulatory reporting. Just going back to, and actually let me make one more point. As far as where things may conflict, where you may have conflict in information. So one thing I think is helpful is to have some sort of cross-reference where you can cross-reference all the various reporting standards. We'll cross-reference GRIR with SASB, with UN Global Compact, with IPECA, as I mentioned. But that also allows you then to give context, perhaps where there may be either a conflict or maybe even information that you cannot disclose because it's just not applicable to your industry. So, and again, I know, like, beating the drum here, but I think where the SEC can help is just, again, trying to drive towards some level of standardization. I like what Mr. Coates was saying, is perhaps you start, just trying to standardize within the US, and then maybe that can influence internationally. So I think that's probably the approach, but that's certainly what we've done. And that's, over many, many years of reporting.
And Rudy, you already face US banking regulations, you face European banking regulations, you probably face Japanese banking regulations. So having different regulations apply to you is not a new story, but, do you worry at all about, given the various standards, how you can really comply with everything at once?
The short answer is yes. Listening to Alex, I have to admit, I wish I was in a different industry, because the way he presents it, it sounds a lot better. I would say that you're absolutely right, David. We are subject to regulation, and typically in countries, we're subject to two types of regulation: securities, market oversight, and banking. So there's a lot of complexity out there. I would just add to the conversation. We are now in the process of addressing some new EU legislation, also in the UK, with respect to green ratios. And so we're working that through. It's an end of the year, and there'll be certain disclosures. Additionally, there'll be some regulatory schedules that have to be applied. So that's a lot of extra work. And it's but let's face it, regulatory reporting for banks is constantly expanding. It's been expanding for years. So like the universe is expanding, that continues to expand. The one point I would add, though, that I kind of scratch my head on is, let's face it, in the end, you'll be disclosing a green or a brown ratio, to tell how your lending is and your loan portfolio as such. And does that drive us to managing our exposures, our assets, our portfolio in a different way than we will for, let's say, the top of the house disclosure requirement? So there's an extra bit of complexity of how you have to think about how you're managing a particular subsidiary versus the top of the house. So, just an added aspect of, I would say, unneeded complexity.
Well, and local regulation often has that impact where you've got the, diverging interest potentially. John, I guess you do have some international operations, but you also have companies that operate in different jurisdictions. How do they try to deal with this, and how is you try to get the information be uploaded so that you can use it for your own filings? Does this create any huge issues, or is it just something everybody manages?
No, it's a huge issue. I mean, the data collection and how to do this in a seamless way with, as I said before, with 8,000 real estate properties and changing and 200 portfolio companies, it's a huge challenge in terms of the data collection. And as I started out with, because we're very transparent, we've not completely cracked it in terms of that's perfect for our industry to put together the data. Having, on the other side, we address ESG issues with our portfolio companies all the time. We do surveys on a variety of ESG issues with them. We inspire them on ESG issues. We show leadership on ESG issues, but the data collection specifically to make it seamless, easy, is something we're working on and has been an impediment to where we'd like to be and hope will be sooner rather than later.
Maria?
I've heard less about this because we're more domestically focused, but I do think that probably the challenges, like John has mentioned and Rudy, have led to more conversations at the roundtable about the international aspect of this, and this was covered a little in the previous panel, and how might we look to rationalize all of this and be more helpful if there's a way to do that. So, but we are more focused on responding to the SEC.
Okay. We're nearing the end of the time, and I want to give each of the panelists an opportunity to sort of address to the SEC, what specific guidance they want to give them or advice or things of that nature. And, let's start in reverse order from where we did it the first time. Take a minute or two. Maria, do you want to go first?
Sure. So, I guess, some of my closing thoughts are that, again, that the SEC should remain true to its mission throughout this process, focus on, protecting investors, maintaining the fair and orderly markets, facilitating capital formation. That approach would serve everyone well. We didn't get to it, but the human capital issue, give it a chance. Let's see how, I know that there's real urgency as, after climate to focus on that, or maybe simultaneous, but how about we look at how that might be working? One thing that, as we've tackled, we've gone more deeper into this ESG reporting issue over the past year is how it's just striking us how enormously complex it is. So again, I think the SEC has every intent to do this, but to continue to seek as much input as possible. We understand the urgency, we understand the desire to act, but I think that it's important to to hear and the fact that issuers, that's who I speak for, they are engaged, they want to respond carefully, constructively, and I think that we're going into this with an open mind, as I said at the beginning, and very much want to make sure that whatever is done is workable and reflects how important the issue is. So.
Thanks, Maria. I think that it sort of brings to bear something that John Coates raised this morning, which is there is an open comment file here, and people that want to be heard, the sooner that they submit it, the more time the SEC will have with it. I'm sure the BRT and other organizations will do some comprehensive letters. But I will tell you, just from my own experience, individual companies that have a particular view, it makes sense to, you're not going to get penalized for putting in the comments. It makes sense because the SEC, it wants to do something that works from a practical perspective. And many of these issues in different industries and different companies are going to have different impacts. And I would urge people to use that comment letter process to do so. Rudy, your final thoughts?
Yeah, just three real quick. One is I think the SEC should build on existing standards. In the context of climate, I would say that's TCFD and SASB. It's a good solid base. So let's see what we can evolve out of that. That's number one. Number two, I really think the whole question of defining materiality has to be addressed. Tons of judgments are put into thinking through each disclosure and such, and to just sort of let that evolve on its own just doesn't feel like the right answer. The third is I think the SEC has to find a way to, or a mechanism to allow the whole, the whole area to mature so that companies have a time, with a little bit of protection or time or however you want to do it, to get the right type of capabilities, controls in place, as well as that common understanding, so that, people aren't exposed until that maturity is there. Those are my 3 points.
Alex, what's your perspective, closing remarks?
Yeah, no, hey, I'll keep mine brief too, because I think it's been covered already, but I would just say, avoid the temptation to create anything new, support, maybe convergence of existing standards. I think that'll be the quickest way to get reporting going. And then I would just say, I definitely agree with Rudy, the whole definition of materiality, what that means, and certainly involving, multiple stakeholders. I know whether that's individual companies or industry groups, those groups are going to have valuable input and be able to explain some of the complexities. I think that's necessary. So that's me. Thank you.
Okay. John, let me give you the last word on today's panel. So
thank you. So first, I would be suspicious of this time is different kind of thinking. Yes, innovation is great, but there are tried and true principles that have served the commission well, and I would stick to them. Second, I'm actually pretty optimistic in hearing what I heard throughout the day, because I looked before the session, I looked at that joint statement that Commissioners Lee and Crenshaw did in November when they were pretty disappointed that there wasn't more done on climate risk. And they said, look, the good thing is we're going to be able to move forward with a lot of comprehensively going forward with rulemaking, which I think is really good to do it through rulemaking because there's consensus building, there's a clear articulation of what's the basis for the conclusions. You tend to get higher quality with the rulemaking process. And secondly, they said that the commission should have an internal task force and ESG advisory committee that is dedicated to building upon the recommendations of leading organizations such as the Task Force on Climate-Related Financial Disclosures. And we've really heard a lot about that today, about the benefits of that, which I won't repeat, but it makes me optimistic that there really could be some common ground in terms of leveraging with what is out there already, which would address many of the concerns that have been articulated today.
Thanks, John. And let me join everybody thanking. We have a terrific panel today. I really want to thank John Finley, Rudy Blass, Maria Gazelle, and Alex Habian for participating today and helping bring the roundtable to a close. Before I close the roundtable, I'd like to share some of my personal thoughts about the SEC's role in formulating ESG disclosure. As John mentioned, many of you have probably heard or read about an article that Laura McIntosh and I published yesterday that says that we really should maintain our current definition of materiality and not follow the European approach. We're working on another article that talks about how ESG disclosure should be considered in this context, but let me preview some of my personal thoughts. There's no doubt that the US is lagging behind Europe's approach on ESG disclosure, but that doesn't mean we should follow Europe's approach. We have the opportunity to do it better and to do something that we know will work with our reporting system. And so we should take this opportunity to do that. As the discussion on corporate purpose continues to develop, we already see companies and investors increasingly focusing on stakeholder interest, expanding beyond the typical focus on shareholder interests. And I think that it's time that disclosure sort of caught up with that to some extent. ESG disclosure can no longer be ignored, but to measure the differences between companies in a particular industry, we need a common set of metrics and standards. That's going to have both qualitative and quantitative aspects. However, the metrics and standards need to take into account different industries, and as John pointed out, not try to provide a one-size-fits-all approach. SASB does that today for about 70 sectors and industries. Hopefully that will continue to be built upon and be useful. I think ESG disclosures need to go beyond the sustainability and climate issues and need to address human capital issues as well as diversity, equity, and inclusion. But maybe we can use the climate disclosure as a method to develop a model for the disclosure, and so it can be tailored to the other issues that are obviously much broader than climate change. ESG disclosures can be material for particular companies and industries, but it's unlikely for an ESG issue to be material for all companies. And so I believe it's a mistake to try to characterize ESG issues as something that is, material disclosures for each company. Materiality is a different issue here. We also need to look at who the beneficiaries of ESG disclosure are going to be, and that obviously goes beyond the common shareholder framework. Companies who fail to require all material information obviously are subject today to litigation from the shareholder plaintiffs firms. I don't think that we should be changing that. I'd love to see less litigation out there, but I don't think that that's part of this mode. ESG disclosure is a different animal. To the extent that the SEC requires company to make ESG disclosures of items that are not separately material, my view is that those disclosures should not be subject to third-party litigation, but instead should be policed by the SEC and DOJ. Obviously, this would require that the SEC beefed up its enforcement resources, but that's not a bad thing from my perspective. It's actually a good one. In addition, as some people mentioned today, the SEC really needs to leverage off the expertise that other government agencies possess as the SEC develops ESG disclosure requirements. Agencies like the Department of Labor, the Environmental Protection Agency, the Department of Energy, and many others should be part of any process that results in new disclosure requirements. Moreover, as referenced in John Coates' comments this morning and some of our other panelists today, I think we need to take a long, hard look at private companies if this is seen as a societal benefit, and the need for private companies to do similar disclosure. Maybe the market will drive them toward that end, but I don't think that that's going to really be the case. And my concern is that then we're only seeing a partial picture of the real story. I personally believe there may be ways to have the SEC force private company disclosures in this context, but obviously that's going to be very controversial. But we also don't want to give public companies yet another reason to go private to escape disclosure requirements. That in and of itself would be a big mistake. So the SEC does need to act now. It's not something that can be postponed. I think safe harbors for disclosure that meets approved standards can be a useful approach in line with some of the other ideas that were floated today. And really standards and metrics are something that we really need to spend time and focus on. As John White noted, we need to make sure that the SEC has the authority here, which personally I believe it does. And the costs and benefits of such disclosure should be addressed and articulated as rulemaking progresses. And look, as much as it'd be nice to have global standards for ESG disclosure, I think waiting till that time occurs is going to be a mistake. Europe's Napoleonic approach, as John said, will not work in the United States. And the effort to sort of get to global standards, I think, is going to delay meaningful ESG disclosure in the United States. And that's really coming to the close of this. That's something we cannot tolerate. These disclosures are likely to make the world better for our children and our children's children. That's investors and companies alike. The status quo where the disclosure is not very meaningful does not help shine a bright light on the issues that need to be addressed. And if they're not addressed and improved in our lifetime, they may never be resolved. So that's my perspective on the SEC's role here. Turning back to the roundtable, as we bring this to a close, I'd like to thank John Coates and the SEC staff for all their efforts and guidance, the panelists on our 4 very comprehensive panels, and the 3 professors who made this roundtable come together, Professor April Klein from Stern's Vincent C. Ross Institute of Accounting Research, and Professors Ed Rock and Rob Jackson from NYU's Law Institute for Corporate Governance and Finance. I'd also like to thank Ryan Gibson and her colleagues for all their hard work behind the scenes. We greatly appreciate the support of the deans of Stern and the law school for the roundtable. And lastly, I'd like to thank you, the audience, for your attendance and participation. We had more than 300 people sign up for the roundtable, and we're going to put this on our website and on the Institute for Accounting Research's website so that others have access to what I think was a very useful discussion today. So thank you for attending. Thank you everybody for their participation, and stay safe.